There we go. Well, Happy New Year, folks. Good way to start the new year with an argument, I guess. Anyway, we have almost 6 hours of argument time requested. I ask that you give us the time that you need, because we're, as you know by now, have read the record, read your briefs, know your arguments. So that said, let's get right to it. People versus Ryson Smith.
Appellate request 8 and 2.
8? 3 and 2 versus 8? Oh, okay. Give me,
She said 8 and 2.
oh, I'm sorry. I'm sorry. My ears are clogged from New Year's. You said 8 and 2? All right, I'll give you 5. Oh, hang on a second. I got my notes here. 6 and 3 and 6. Okay, and if there's more time, we'll keep going. Thank you. Hang on a second. Second case up, 5 AIF Sycamore versus 201 EB. All right, 5 and 3 and 5. Thank you. Atria UB versus China R. That's submitted. Number 4, Lanes Covering versus Delilah. You want 10 and 5? All right, I'll give you 5, 3, and 5. Next case up, Marizuka versus 201 Water Street. Okay, 5 and 3 and 5, thank you. Wagner Associates versus PC.
Appellant request 6 and 2.
All right. 6 and 2 and 6, thank you. People versus Daquan Johnson. Okay, we got 5 and 3 and 5. Abdul Fattah versus River Bay Corporation.
Appellant request 5 and 5.
Okay, 5, 3, and 4. 10 and 11, Churchill Owners versus Kent.
Appellant request 8 and 3. Respondent request 5.
Okay, 5, 3, and 5. Thomas versus Tribal Maintenance.
Appellant request 8 and 2.
Okay, we got 5 and 3 and 4. Karen's versus City of New York.
Appellant request 5 minutes for argument and 3 rebuttal. Respondent request 5.
Okay, 5, 3, and 5, thank you. People versus Jashawn Brickhouse, that's submitted. Bautista versus New York City Housing Authority is submitted, thank you. Okay, first case up, People versus Rashim Smith.
May it please the court, Abigail Everett for Appellate Rasheen Smith. I'd like to begin with the discovery statute point. This is a case where the trial was ongoing at the time that the new discovery statute went into effect. The defense lawyer requested all the discovery that they would be entitled to under the new law. Now, at the time,
Counsel, are there any cases where the new discovery statute was applied where the trial had already begun before the statute became effective?
I'm not aware of any cases in that precise posture. However, I did cite in the reply brief a number of cases in the 4th, the 3rd, and the 2nd Department where the appellate divisions found that the statute applied to those cases, even though discovery had already occurred prior to that time and the people had declared ready. So the question
But the
is,
trials hadn't begun in those cases.
I'm sorry to hear
But the
you.
trials hadn't.
The trials
already
had not
begun.
started in those cases. But the courts seemed to be comfortable with the idea that when the law went into effect on January 1st, 2020, that it applied to all cases going forward.
But counsel, this case had started before the law became effective, right?
The trial had started before.
Right, the trial had started before the
That's
law
true, Your
became
Honor.
effective.
Yes.
That's different from any of the cases that you've cited, correct?
That is different.
And would not be an issue of declaring a mistrial on a very complicated trial going all the way back. The witnesses who had already testified might have had to give further information, or it would have created quite a morass. Would you at least?
No, actually, I think that the respondent overstates the potential morass that might have occurred.
Well, at a minimum, we would have had to have a mistrial, right?
No, I don't think so at all. That my position is that the judge should have granted the additional discovery. You see what comes in the nature of that discovery, and then the judge, the trial judge, as in any case.
What is
where-
your argument about what the nature of that additional discovery would be, actually?
What specific pieces of information? Well, we don't know, and that's why the relief that we're requesting is a remand for a hearing, as in the cases like where you have missing Rosario material, you don't know what's out there.
Well, you have to have all Rosario material turned over before you can go to any trial, go forward with any trial, correct?
Correct, Your Honor. I was just
And the
pointing
new
out.
discovery statute was really more about timing, right? When in fact the people had to provide discovery in order to be able to state ready. That's the import of the new discovery statute,
That's
correct?
certainly one of the important parts of the new statute, but the other very important part of the new statute is the vastly expanded nature of the material that the DA has to turn over, and they have to turn it over without a request. So I would submit that in this case, once the law was approved by the legislature and signed in the spring before this trial, all parties knew that this expanded discovery was going to have to be turned over. This is
But the
not a-
effective date of the statute wasn't until well after the trial had already started.
That's true. On the other hand, there were 11 more witnesses called by the DA after this. The judge did not even hold that as to those 11 prospective jurors, that all discovery had to be turned over. So I would ask the court to remand for a hearing so that we can see what material was available.
I have a further question, though. You mentioned the fact that the effective date was well after the date when the statute was passed. And that's a circumstance that the Court of Appeals said in People versus Galindo was a factor that suggested that the legislature did not want it to be retroactive. Given that there was an effective date in the future, isn't that a factor that supports not making the statute retroactive?
I would submit the contrary, Your Honor, that because the legislature gave the people plenty of time to prepare. I cited in my brief, and the lawyer below cited, that in 1979, when the legislature amended...
Is there any case law supporting the fact that a piece of legislation with a future effective date should be made retroactive?
Well,
I
if you
couldn't
look
find
at
any.
Simonson and the cases in the appellate divisions that cite Simonson, that's a significant case respondent relies on, they say that as the things that are done, even procedural things, you don't go back and revisit them. But things are not done, and I would submit that this is not done when you're in the middle of the trial and you still are litigating your guilt and innocence. Now, unless there are any other questions, I do briefly want to touch on the harmless error aspect of the Fry hearing. The Fry hearing, as respondent recognizes, the judge erred. She abused her discretion in not granting the Fry hearing. Now, obviously, the DA's arguing harmless error. I want to stress that the medical examiner testified that the death could have occurred from the incident that morning alone. So even though I recognize that there was a lot of evidence about conduct that preceded that morning, the people had to prove beyond a reasonable doubt that he had...
What was the people's theory, right? It was in concert, correct?
That was the people's story.
So
That's
so
not the answer, Your
If
Honor.
it was, all right, let me let you, since you're not going to let me get it out, let me
I'm
let you
sorry.
go.
Go ahead, Your Honor.
Go ahead.
Yes, it's an accomplice, but since the medical examiner testified that the blows that were stricken that morning alone could have caused his death, if the jurors accepted that, and Perkins testified that the child was hit 5 times.
So now let me ask you,
Okay.
what was the cause of death?
The medical examiner's, her opinion, her main opinion was
Did you-
it was
okay.
an ongoing cumulative.
Exactly. So the
Right.
cause of death was not, in the medical report, was not simply that morning's.
But that's not accurate, Your Honor, because on cross-examination, the ME who testified, she conceded there was a viable scenario. It wasn't her preferred opinion, it wasn't, but she did acknowledge that those blows that morning alone. And if the jury wanted to accept that that was the cause of death, the fact that this is, she testified the child was hit 5 times with something that looked like a wooden table leg, and then she threw it in the trash. And the DNA, without this FST statistical analysis, there was no DNA connecting Mr. Smith.
Counsel, didn't you, in your argument, downplay the importance of the DNA when you argued that, of course you would expect his fingerprints to be on there, he lived there?
I would say that once the judge ruled that this was coming in, the defense lawyer below had to make the most effective arguments that could be made. But that's not,
That's a pretty effective argument, he did live there.
well, except when they did the standard DNA testing, there was no DNA evidence connecting him to anything that the people found in the apartment and offered into trial. So that kind of cuts against the idea that, of course, his DNA was over
Was the jury made
everything.
aware of that?
Excuse me?
Was the jury made aware of that standard DNA did not connect the defendant?
Yes, they were aware of that, Your Honor.
Thank you.
I
You'll
see
have
my
rebuttal
lights
time.
up.
Thank you.
Good afternoon, and may it please the court. Stephen Kress on behalf of the people. If I can, I want to just pick up where we just left off in talking about harmless error. The medical examiner testified 3 times, specifically, that in her opinion, her expert opinion, the cause of death was fatal child abuse syndrome, not the final beating that happened on September 26. Could she say to an absolute medical certainty that that final beating was not the cause of death? No, she couldn't. But it was very clear that it was her opinion that this was a cumulative, chronic abuse cause of death. And there's absolutely no reason why the jury would have rejected that. It's not like there was another expert at trial who disagreed with her. So I think we're starting from the standpoint that the cause of death is fatal child abuse syndrome. And there was just absolutely overwhelming evidence that the defendant was involved in these beatings, not just involved, that he was the principal actor here. I mean, it wasn't a 98-pound woman with lupus who was breaking this child's bones and literally shredding the muscles in his arms and legs. So I think that very clearly establishes his mens rea, and also that he was actively participating in this crime.
Let's get to the discovery motion that was made during mid-trial.
Yeah, sure, Your Honor. So I think even if we start, I mean, obviously we argued that the statute wouldn't apply to pending cases, and I think as Justice Gesmer pointed out, that there's very strong indication from the legislature that it wasn't supposed to because of the effective date being postponed so far out. But even if we are to assume that this statute applied going forward once January 1st hit, at that point, the trial had already started. You really would be wiping out everything that had happened before then. And the case law is very clear that in those circumstances, you need a clear statement from the legislature authorizing that kind of...
Why not provide the discovery with regards to the 11 witnesses that had not yet been called?
Well, I think, Your Honor, because at that point, again, like, there's nothing in the statute that would require us to provide that information once the trial has already begun. Even under the new statute. I mean, there's Article 245-60, talks
Under
about...
the new statute, you don't get to trial unless you provide it, right?
I'm sorry, what did you say?
Under the new statute, you don't get to trial unless you provide that material.
That's right, but we've already gone to trial at the time that this law takes effect. But I think that's actually a reason why the statute can't be construed as applying retroactively in this case, is because,
Go ahead, I'm sorry.
I was going to say that Article 245-50 has a mechanism for filing a certificate of compliance once you've provided all discovery, and it specifically ties, a declaration of readiness for trial to provision of discovery. Once you go to trial, you can't move to dismiss on speedy trial grounds anymore under the CPL. So it really just doesn't apply in a case where the trial has already begun. And I also want to say, just in response to my adversary's point about how we should have known in May of 2019 that, obviously we knew that the statute was going to take effect in January 1st, 2020. That doesn't mean we knew it was going to be applied to cases that were pending at the time or cases that had already, where the trial had already begun. I think that kind of begs the question. I'm happy to address any other questions from the court. Otherwise, I would ask that the judgment be affirmed. Thank you.
Thank you.
I just would like to stress from the point of view of what might be viewed as a drastic remedy that the cases of King and Robbins and Brown and the other departments that I've cited in my reply brief, those are cases where not only did the appellate divisions recognize that the new discovery law applied to cases where the people had already declared ready, but they upheld or ordered dismissal of the charges. So obviously, the legislature intent on this has been held to a very strict standard. I would also point out that in 1979, when the legislature amended the discovery law, they provided that the trial judge would have the discretion when it would, quote unquote, work an injustice, not to require all the discovery required under the new discovery statute. But as the defense lawyer argued below, in this case, there was no similar provision in this legislative action. So I think that the legislature knew how to give the trial court an out if there was a feeling that it would be unjust in a particular case, and they did not do that in this circumstance. And on the other hand, I do want to stress our position that this would not have required necessarily a mistrial. It's far too early for this court to know what the ultimate relief would be. We're requesting a remand so that, as the defense lawyer fully argued below, we can see what information was out there, and then the trial judge will have the opportunity in his or her discretion to assess whether or not this would make a difference, whether or not at this point a new trial is required. If it's something that the lower court would find so significant that a new trial would be required, I don't think this court really wants to prevent that kind of an inquiry. I don't think that we're talking necessarily about insignificant matters. For one thing, the trial lawyer argued below that he had not been given access to grand jury testimony of people who did not testify at trial, something that you're currently entitled to. So that in any case that's on trial, the defense lawyer may become aware of information during the course of the trial and say to the judge, I need to recall a witness, I need to ask the question, so that this is a fairly common circumstance that discovery is
You're
in flux.
saying that there are going to be hundreds of cases that were in mid-trial?
No, Your
So
Honor.
that's exactly what I'm saying. This is a really rare thing. It's not really going to affect the application of the law. It's just this one unique circumstance.
Right, and maybe that's why, since it is probably such a limited, and there may be evidence out there that's significant, that the court should be motivated to remand for an inquiry in this case, since it's not a circumstance of floodgates, and it's fully preserved. The judge below said, you know, I think you have enough. I'm going to leave it up to the appellate division, and I'm asking the court to find that the judge at her discretion should have ordered additional discovery when it was requested. Thank you very much.
Thank you. 5 AIF Sycamore versus 201. Go ahead.
May it please the court, Eric Valley on behalf of plaintiff. Plaintiff asserts that in this mortgage foreclosure case, it's a commercial foreclosure case, which is fairly simple. I know that gave a chuckle to the justices a few months ago. That in Bixby versus Broom, decided by this court on October 31st of 2023, that the court decided that the assignments of mortgage were valid and enough to confer standing upon the plaintiff. That is the case here. It is the same.
Except that the last two assignments prior to the assignment to your client didn't refer to the assignment of the note.
The last two assignments said,
Several of the earlier assignments referred to, at least obliquely, something about the note. But the final assignment to your client, in its text, it never uses the word note, and certainly doesn't say that the note was assigned.
it actually
So how
does.
can we find that?
It actually does in the paragraph 4. It refers to the note. It says in the.
But there's no paragraph 4 in your last assignment.
Okay, but in the first paragraph, it says, together with the obligations therein described, all money is due, all rights arising from them, and all documents associated.
It doesn't matter.
It doesn't refer to the note.
It refers to the note in the
Implicit.
references.
But it never actually uses the word note in the final assignment, right?
It does use the word note.
Where?
In the brackets, in the warranty section, it says including the notes therein, or including the
I think
notes.
so. What pages you claim that's on?
Uh-oh.
I looked and looked.
I have to get all the way to the assignment, I apologize.
Let's read this very carefully.
Paragraph 4, including any related property.
Page?
note. Page 2. It should be page 2.
Page 2 of what?
Of the assignment.
The notes and mortgages were signed 8 times that day, right?
Right, by the
So
same
let's
party.
look at, it doesn't matter, honestly, in terms of the law, it doesn't matter. Let's look at the last one to your client, okay? The last one to your client has a paragraph 3 and then a paragraph 5, right?
I'm sorry, it would be
I'm sorry, 4 and then 6.
4 and then 6.
It's 563 of the record.
7, Paragraph 4, I'm looking at it right here, 2021.
The one that we have in our
nutmeg.
record that has a paragraph 4 and then a paragraph
Page
6, right?
556, Your Honor.
Right. Where's paragraph 5 that says,
No, I'm saying paragraph 4. That's
no,
what I said.
I'm talking about what are the paragraph numbers in the last assignment?
I understand, there's a missing paragraph.
That's the paragraph that says the notes.
Right, but also the paragraph above that says including any related promissory note.
That doesn't define the notes that are being assigned, right? Why was paragraph 5?
What about all of the assigned loan documents?
Hey, we ask the questions, you don't.
Well, what I am saying to you is if you want the court to say, as a matter of law, that there was an assignment, it has to be in there straight up. You might be able to prove it with other documents, but that document doesn't prove it as a matter of law. It just doesn't.
Okay.
So what else?
So,
Let me just go back to your paragraph 4. It does use the word note, but it uses it in the context of saying a signer makes no representations or warranty of any kind or nature whatsoever with regard to the mortgage or any other assigned loan document, including any related promissory note. So that doesn't do you any good because it refers to the note as what you're not assigned, is what is not being assigned.
okay, well, we believe that the first paragraph says
So is
all.
there any case law supporting your claim that an assignment of a mortgage that doesn't explicitly say, and the note too, constitutes a valid assignment for the purpose of being a foreclosure plaintiff?
I don't know that there's any case law that specifically says that.
Thank you.
But there is case law that specifically says, the only reason that the assignment.
You want us to make new law and say an assignment of a mortgage that doesn't specifically say, and the note also is good enough to make you a valid plaintiff in a foreclosure action?
No, the case law that I want to make is that they're referring to every single document signed on that date.
Right, but
as
you
part of
want
the
us to
loan
say it's
record.
good enough if it doesn't ever say, and
Yes,
the
I do.
assignment of the note. Okay, but there's no case law otherwise that supports that.
Not that I know of, Your Honor.
Thank you.
As to the second point, Your Honor,
You got, the second point that the judges, okay, go ahead.
with the Rhodes affidavit. The Rhodes affidavit was submitted in reply. The defendant, we annexed a note to the complaint with all of the allonges.
Okay, you get that on rebuttal. I thought you were replying to Justice Gesmer. Thank you.
May it please the court, Jake Beater on behalf of respondents.
So you know where this is going, the arguments are going. So where, does it say the note or not?
I'm sorry?
Does the assignments refer to the note or not?
Assignments do not refer to the note, and in fact, they
So, I'm sorry, I don't want to, go ahead.
they expressly refer to endorsed to assignee on that date. As,
Okay, let me ask you this one question. Other than the fact that you raised standing, you don't deny that you didn't pay. There was nothing in your opposition to summary judgment motion that said, we paid this note off, we have other defenses. The only thing you said in your motion, in your opposition was they haven't proved that they lack standing, correct?
That is not brought up on appeal, no.
No, I'm just asking you, below, the only defense that you raised in opposition to their summary judgment was standing, correct?
That is correct.
You never said I didn't pay, we paid the note. You never said we had any other defenses.
That
So all that has to happen here is that it has to go back for a motion where they prove their standing because you haven't asserted any other defenses, right?
Standing remains an issue. That
Okay,
is an
but
issue
you
for
did,
trial.
and in opposition to summary judgment below, you didn't assert any other defenses. You can't assert them a second time if you didn't assert them the first time, right?
Standing would be an issue at trial.
Okay, that's it. That would be the only issue. And so there could be a motion to renew, there could be a really quick trial on that. I just want to, we're all on the same page on this, correct?
Standing is a critical element.
I'm asking you to answer my question. Do you agree that the only issue you have raised in opposition to foreclosure of the note and mortgage is standing?
On summary judgment, yes.
And so once you don't raise it after summary judgment, you can't raise it again because you had your chance and you didn't raise it. So that is what I want us all to be clear on, correct?
That is correct.
Okay.
The only defense that was offered in our opposition to motion of summary judgment was standing.
And, right, okay. So once you don't raise it in opposition to summary judgment, then you don't get a chance to raise it any other time because there's your spot to do it.
That does not make our standing argument any less sufficient.
Oh,
to defeat
absolutely.
summary judgment.
I'm just trying to figure out, like, this is all that's left is standing, right? And there was a reply affidavit that the court below said you can't do on reply.
Correct.
Okay, I'm good.
And I would also point out the reply affidavit, in addition to being inappropriately submitted for the first time raising new arguments, it also did not actually establish standing with respect to the allonges because it merely indicated that the client informed his attorney that he had inspected and that the notes were firmly affixed. That is not sufficient to establish standing, which must be, to establish that the allonges are firmly affixed, which must be clear and unequivocal.
Or you can just say in a new affidavit, I possessed the notes at the time I started this action, right? That would be enough.
Not under this motion, but yeah.
Well, yes, you could just do that. You could have somebody testify or put in an affidavit that says, I possessed the notes at the time of the commencement of the action.
At trial, that is certainly something they can offer.
Okay.
Counsel, in their reply papers, plaintiff argues that their argument is strengthened by our recent decision in Broom Lender LLC versus Empire Broom. Do you agree with that? And what's your view as to whether that affected this case at all?
I believe Broom is distinguishable for the reasons the court addressed already, which is there was one assignment and it was clear. The argument against the assignment in Broom was that it didn't properly refer to the property. However, the mortgage included a CRFM number and properly referred to the property. In this case, as the court has noted, there was no reference to the note specifically, and in fact, as I mentioned earlier, it specifically said that it endorsed to the assignment on this date was the language that was contained in the assignments of mortgage. The assignments of mortgage clearly referred solely to the mortgage and not to the note. If the court has no further questions, I'll yield my time.
Thank you.
Thank you, Your Honors.
Your Honors, as I began to say, in the reply affirmation, the first time the defendant stated that the note was not firmly affixed was in their opposition. Pursuant to CPLR 1013, they're required to plead with specificity. Their answer simply said plaintiff does not have standing. Under the laws of the state, we put in the note and all of the allonges, which this court, the Second Department, the federal courts have said is prima facie proof of standing and possession of the note at the time of the commencement of the action. Okay? So in opposition, they finally said it's not stapled. They could have said that in their answer. They didn't. So the only time we could address it was in reply.
What case law supports the requirement that a defense stating they don't have standing has to be pled with specificity as if it were an allegation of fraud or something else?
Well, this isn't an allegation of fraud. This is
No, I understand it's not an allegation of fraud. That's my point. Allegations of fraud have to be pled with specificity. What in the case law or requires that a defense of standing has to be pled with specificity?
The statute itself, it says a party has to do their pleadings with specificity with enough notice to allow the parties to know what they're alleging. We had no idea what they were alleging. They said, you don't have standing. The courts of this state said, annex the note, annex the allonges. That's what we did. It was a single exhibit. Then they said it wasn't stapled. In reply, Mr. Rhodes said, I conferred with my attorney, I checked the note, I physically did it myself. It was stapled. What else are we going to get at a trial?
You know, counsel, that's a very, that argument, you know, you have a prima facie burden, right? So you got to check off all the boxes. So standing is whatever standing is out there in terms of what you need to satisfy. And the fact that, you know, I thought about what you had argued. On reply, you're just going back to check off boxes that you missed. That's not permissible under the case law in this state.
The case law doesn't say you have to annex it and prove that it's stapled. How can we scan in a document that's
Oh, you could just do what the affidavit that Rhodes just said on reply. You could have done that on your prima facie.
And in fact, you do have to prove that the allonge is attached on your prima facie. You do have to do that. You can't just say, and I have an allonge in another document, because otherwise you haven't proved standing. Part of proving standing is to prove that the allonge is firmly affixed. And that is true. You can put the allonge in, but you have to prove that it's part of the document.
But that's the same thing they did in City Mortgage versus Jansen. They said in opposition, you didn't have it on this date in Jansen, right? And the plaintiff said in reply, yes, I did. Here's an affidavit proving I had it on that date.
No, that's a different thing.
That's a different.
That's a different thing.
Way different.
Totally different.
I say that it's not different because if they didn't have standing on the date, if they didn't possess the document on the date, that's one of the check boxes, as Your Honor.
You were trying to prove standing through the allonges, not through possession. That's a different thing. You could have easily put in on your motion for summary judgment an affidavit that says, I possess the notes at the time the action was commenced. The
affidavit did say they possessed the notes.
At
The
the
affidavit,
time
absolutely.
the action was commenced.
Absolutely. The affidavits did say that they possessed the note at the time the action was commenced. It didn't say it was stapled.
Right, okay. So that's what I'm saying.
Okay, we got it. Thank you very much.
Thank you, Your Honors.
Lane's floor covering versus Delilah.
Good afternoon, Your Honors. Happy New Year. May it please the Court. Alex McBride, on behalf of Plaintiff Appellant Lane's Floor Covering and Interiors, Inc. Your Honors, just by way of brief background, this case involves Lane's. It's a small local business, family-owned.
Look, you have two sets of checks here. You got the post-September 2013 checks, the 5 checks, and you got the pre-September 13 September 2013 checks, or the 60 checks, was amounts roughly to $850,000.
Correct, Your Honor.
This appeal, at least my understanding from what Supreme Court did, we're looking only at the pre-September 2013 checks, right?
That is correct, Your
Okay,
Honor.
great.
Yes.
I want to get that framework.
Yes, and just to jump to the point on those checks right away, those checks are timely and cognizable. First of all,
Let me ask you a question. The question here that we have is that, at least I have, is that you investigated or you did something that alerted you in December of 2013 when the former controller abandoned his job, and you thought, well, what's going on here? And you did some investigation in December of 2013. You found, based on the record here, 5 checks that were allegedly fraudulently negotiated, right, for about $60,000. Why can't we say that that's inquiry notice of the other 60 checks going back?
Well, Your Honor,
and then you're relying on the fact, we read the stuff here, relying on the fact that that you had a DA investigation in 2016, and then in 2017, your own investigation, you're like, aha, you made a motion in 2018 to amend to include the 60 checks, what we all said was okay to do. We reversed Supreme Court. So the inquiry notice is the real crux of this issue here, right?
Well, it's not necessarily, Your Honor, because even putting the discovery rule aside, and I have an answer to your question, we still get the benefit of the 6-year look-back period from the time we filed the complaint. We filed the amended complaint in 2018.
Where do you get the look-back from?
Well, 6-year statute of limits.
From when you discover.
Your Honor,
You don't get an automatic 6.
the fraud statute of
It's
limitations.
not this is not a rent stabilization case. I don't think we got lookbacks here.
My understanding is the statute of limitations for fraud is the greater of either 2 years from the time you discover the fraud
Yeah.
or 6 years. Putting the discovery rule aside,
Right.
the complaint alleges fraud of the vast majority of the checks were within 6 years of the filing of the
You're
complaint.
overlooking the UCC component of all this, right? I mean, the UCC component has a 3-year statute of limitations, so that and the UCC provisions, as Supreme Court was arguing, or at least wrote, doesn't apply when you have independently sufficiently pleaded a fraud claim. Fraud is outside of the exceptions to the UCC rule, so that all your other claims that you, like restitution, unjust enrichment, those all go by the wayside. The UCC covers that, except fraud.
Your Honor, very quickly, the UCC does not have a statute of limitations. I think my adversary acknowledges that in his opposition brief. The courts look to the common law. Just sticking with fraud for a minute, it's absolutely 6 years. If you look from the timing of our original complaint, which relates back to our amended complaint, the vast majority of the fraudulent checks are within that 6-year window.
So would you concede then
sections
if you
must
didn't have the
survive.
would you concede then if you didn't have the 6-year statute of limitations, that you would be time barred under the notice provision?
No, we would not, Your Honor, for multiple reasons. First of all, as I said, the statute of there is no UCC statute of limitations. You look to the common law antecedent. There is a common law antecedent for claims brought by a drawer against a drawee bank for improper endorsements. That's a municipal credit case in the brief.
I'm asking a very simple question. If let's just say you don't get the 6 years,
Yes.
the other half of the CPL 213.8 is that the discovery rule, the 2-year discovery rule. So why isn't the 2-year discovery rule not satisfied when you had, at least in December of 2013, you found 5 checks? You're out of time if you in that regard.
The answer to that, Your Honor, is we had a suspicion of fraud on the part of the principal employee, Smith.
Yeah.
But it wasn't until the meeting with the Manhattan DA in December of 2016 when we learned for the first time that the defendants were being actively investigated by the Manhattan DA, that the Manhattan DA had...
So the fact that that this high-level employee in your company had cheated you with regard to 5 checks didn't cause you to think, well, maybe he'd done it as to more, and didn't put you on notice that you ought to go back through all the checks during the period that he was employed?
Your Honor, the meeting with the Manhattan DA was...
I understand about the meeting with the Manhattan DA, but I just don't understand why in 2013 you didn't sort of there wasn't a collective scratching of the head and say, gee, we need to have somebody go back through all the checks during the time that this guy worked for us. Why didn't that happen?
Well, my understanding, Your Honor, is that some of that did happen, and then after the meeting with the Manhattan DA, the comptroller of
That's your
Lane's
hook.
Flooring
That
went
was
through
4
multiple
years
bankers'
later that
boxes
investigation
to try to
was done.
unscramble the checks. And by the way, we don't have the discovery that was given.
Okay,
from the
thank you. We get time in rebuttal. Thank you.
Thank you.
Happy New Year, Your Honors. Bruce Goodman on behalf of the respondent, Valley National Bank in Delalah. Your Honors hit on a very important point. When Smith failed to show up for work on December 23rd, 2013, and this is their allegation.
No, let's assume that. I just want you to say why, I want you to address the statute of limitations issue, right? So the action is commenced when?
They filed their original complaint in September of 2016.
2016.
Correct.
So then what is in your view, is the statute of limitations for checks that were before 2013? Because we're all in agreement that the ones after in the original complaint are still in.
The statute of limitations, and we addressed this in our brief, the statute of limitations for a claim pursuant to 4401, which is what this claim is, it's that the bank paid checks that were not properly payable. And the reason they weren't properly payable is they either had a forged endorsement or were missing an endorsement. And the statute of limitations under the UCC is 3 years.
3 years, even if you plead common law fraud.
Common law fraud is displaced. The whole purpose of the UCC...
Let's assume it's not.
Okay.
Let's assume. What is your position then as to what the statute is?
Well, under the they knew in December of 2013 they were on reasonable inquiry notice.
No, you're missing. I think, let me see if I... 6 years. We're looking at 6 years for fraud.
If there was a, right, if there was a
13.8.
fraud cause of action,
Yes.
statute of limitations would be 6 years.
So why isn't 6 years here?
Because fraud is displaced by the UCC provisions. I mean, that's
It's a collective eye.
that's exactly the point.
That's the exception.
The whole purpose of the UCC, it displaces common law.
Except for fraud. Fraud is an exception to the UCC under the case law,
Well,
right?
what they're really alleging is commercial bad faith.
Yeah.
Right, and that's the prudential case.
It doesn't get you the 6 years, but gets you the 3 years.
It's a 3-year statute of limitations. Absolutely. Right.
Either way, because they're alleging bad faith, they're alleging intentional conduct, not negligence.
Well, I would submit, Your Honor, that their complaint actually doesn't properly state a claim for commercial bad faith. All they've alleged, upon information and belief,
I know,
is that Smith and that Dell'Ala was.
So that's a separate point. I'm the sufficiency of the allegations is a separate point, but I'm still on the question of statute of limitations.
So
So you're not conceding, because he said you conceded.
No,
the
I didn't
point.
concede
was
that.
like,
Of
that
course
didn't
not.
sound right, but okay. All right, I just want to make sure you're saying it.
Article 4, this is an Article 4 claim, 4401, bank paid a check not properly payable. The UCC displaces common law claims, and in fact, that's what the Court of Appeals held in the Prudential Bache case, where they went on and said, in that case, there's a
No, but we're not talking, we're talking intentional tort claim, like fraud, which is not covered as a sort of the bank negligently failed to look at the endorsement claim. That's the plaintiff's argument, that I've got a common law claim. Now, let's assume that that's true. Again, I want you to address, what is the statute of limitations for that claim?
the statute of limitations for a fraud claim, which again, we submit, there's no fraud claim here because it's displaced, but is 6 years. So that for the 60 checks that they alleged in the amended complaint, which was filed in July of 2018, any check that was paid prior to July of 2012 would be time barred. But our position is it's the 3-year, the UCC 3-year statute of limitations applicable to Article 4 claims, which is what this is. Payment of a check not properly payable under 4401, and the case is cited in our brief, that controls, meaning that when they try, that their time to assert claims under 4401 on these checks was 3 years from the time that the checks were paid. So for the last paid checks, which were in 2013, they would have had to file their complaint on those checks, the 60 checks, no later than September of 2016, and they didn't do it. They didn't even seek to leave to amend the complaint until July of 2018, 5 years after they were on inquiry notice.
Counsel, I have another. My question is whether you believe that plaintiff stated a cause of action for fraud against defendant Dell'Ala, not against the. I'm not asking about the bank, but against defendant Dell'Ala individually.
No, they have one allegation.
Right. Why isn't that sufficient to state a claim against defendant Dell'Ala?
It's not pled. First of all, that one allegation is pled upon information and belief.
And that's permitted in cases.
It's permitted, provided they identify the source of that information and belief, which they did not. And their argument that, well, we didn't know until we had this meeting with the district attorney in December of 2016 holds no water. Why? Because if you look at the allegations of the original complaint and the allegations of the amended complaint, which was filed long after that meeting, they're identical. In other words, in the original complaint where they're making that single allegation against Dell'Ala upon information and belief, it's identical in the amended complaint. They didn't learn anything from the Manhattan DA. They didn't bolster their allegations against Dell'Ala.
They would also say that's because you wouldn't give them any discovery, right?
I'm sorry, Your Honor?
They also say that's because you wouldn't give them any discovery, right?
And that also doesn't hold water. The minute Dell'Ala didn't show up for work in December of 2016,
Smith.
not Dell'Ala,
Smith.
Smith. Many names. When Smith didn't show up for work in December of 2013, they admit in their papers, they had all of the account statements already in their possession that they could have gone within a week. They could have gone through all of them and identified all of these checks. According to them, it wasn't until 2017 that it dawned on them, hey, maybe we should go search through these boxes that we have that are in storage. And when they did that, and they said, we finally investigated our claim. By the way, 4 years after, a year after they filed it, 4 years after they were on notice of it, they said, oh, here are the 60 checks. And then they still waited another year to seek leave to amend. So they could have discovered.
Let me just ask you something. Assuming that the amended complaint came in 2018, what percentage of the checks were from between after 2012?
Well, So, Your Honor, and I'll concede this point. There are the 5 checks that were alleged in the original complaint, they have valid
Right,
claims.
I know. I'm talking about now, assuming, as counsel says, it's a 6-year statute from the date of the amendment, which is 2018, so it goes back to 2012.
If we apply a 6-year statute of
Right.
limitations to the checks that are alleged,
60 checks.
about half would still be barred if you apply a 6-year statute of
I
limitations.
think your adversary says 29 of them will not be barred. Is that right?
I don't know the exact number, Your Honor. I'm thinking of it in terms of the dollar value of the checks. So of the entirety of their claim, it's about 800.
We'll ask him when he gets up. Well, my information is that he's saying there's 29 checks totaling $375,000.
That sounds about right.
Okay. Okay.
All right, thank you.
Thank you, Your Honor.
Is it 29 checks totaling $375,000?
That's about right if you measure the 6-year statute from the filing of the amended complaint. Our position is you should at minimum measure it from the filing of the original complaint. They easily relate back. They pertain to the same transactions. Original complaint was filed in 2016.
So you think you get 2 extra years for the information that you had in 2016?
Your Honor, if you look at the complaints side by side, they
I'm
are...
just asking you, you're asking us to give you 2 extra years. There isn't a piece of information that you have now that you didn't have in 2016, right?
Our position, Your Honor, is yes, we should get the benefit of relation
Okay.
back on the amended complaint,
Okay.
and therefore the 6 years should be measured. Turning just briefly to the merits of the fraud claim, not accurate at all that we have one single information and belief allegation.
But what else is there besides paragraph 18? There are a couple of later paragraphs that refer back to paragraph 18, but substantively, isn't paragraph 18 all that you will allege? I kept looking, and maybe I missed it, but I...
No, Your Honor, and obviously you look at the
So what other paragraph is
facts
there?
as a whole. We allege that Smith had no authority whatsoever to
Which
transact
paragraphs?
business at the bank. If you'll
Which
indulge me,
paragraphs?
I will.
No, not Smith. We're talking about the person who you're alleging the
What we
fraud
allege is
against.
Smith had no authority to transact business at the bank,
We're
and yet
talking
the
about
branch
frauding-
manager, Dalala, allowed him to do so, and they split patently
In
fraudulent
what
checks between
paragraph
them for
did you
years.
allege that
Right.
in?
Bear with me, Your Honor. I'm pulling up the complaint now, and I will tell you exactly the paragraphs. The other thing, while I'm pulling that up to keep in mind, is under the Prudential case, allegations against a bank employee of fraud or giving rise to fraud can also state a claim against the bank itself unless it's proven that the employee was so adverse that the bank could be off the hook, and Justice Kaye in the Prudential decision made clear that's not an appropriate decision on a motion to dismiss. Now, if you'll bear with me, I'm just pulling up the complaint. It's 175, okay. I apologize.
So, yeah, let me ask you, while you're looking for that, you're saying that we should, this employee's action should be imputed to the bank?
Yes, Your Honor, the Prudential case makes...
No, I don't agree. Let's assume that what facts have you alleged that would lead one to impute a stealing employee's case to the bank?
Well, first of all, he was a branch manager. He was in charge of the entire branch. of the
Okay.
bank. Second of all, the complaint, and I apologize I couldn't pull it up right away, does say that Smith was not authorized to transact at the bank on behalf of plaintiff on lanes. He did it anyway for multiple years.
How is that imputed to the bank?
Because the Prudential case makes clear that a bank or any entity can act only through its agents, and that unless the agent is so adversely against the institution, excuse me for paraphrasing, then at least on a motion to dismiss, the bank should stay in. And that's Prudential. And you'll see that we have facts in the complaint that give rise to a reasonable inference of fraud against Dalala. He conspired, he was friends with Smith. Smith wasn't authorized to transact. They split the proceeds of these checks that lacked any endorsement of American Express whatsoever, no official endorsement, no endorsement whatsoever. And that's why these UCC provisions don't apply, which we didn't get to.
I think that your complaint simply indicates that the bank provided a safe haven for this fraudulent conduct, and nothing more detailed than that to allege fraud.
Respectfully, Your Honor, the complaint does allege that, but it also alleged that the branch manager entered a conspiracy with Smith to cash improper checks and split the proceeds with someone who is not authorized to transact business at the bank. The complaint says that for years.
I have a question to ask you.
Yes, sir.
I'm reading Supreme Court's decision, and correct me if, or tell me if Supreme Court got it wrong. It says, with respect to the statute of limitations, fraud, 6 years or 2 year discovery rule, it says right here, plaintiff relies on the second prong of the statute that allows 2 years from the time of discovery. Do you happen to not argue that in front of Supreme that it's a 6 year rule instead of, because this indicates that you just, the 6 year statute of limitations was foregone and you only focused on the 2 year discovery rule.
We focused on the 2 year discovery rule not because we didn't believe we get the benefit of the longer of the two at the end of the day, but because Mr. Goodman and defendants were questioning the latest in time checks as being outside the 6 year window. Therefore, we've been arguing we get the benefit of the discovery rule because it wasn't until that Manhattan.
Yeah, so, okay, so the bottom line, the point is this is not an inaccurate statement by Supreme Court when it says you focus on the 2 year, and it doesn't seem like, because it seems like if you would argue that 6 years is the one, you'd be going for both. But it doesn't sound like you just tended to just pivot it based on their arguments. Oh yeah, we're only gonna focus on the 2 years, so we don't have.
Well, Your Honor,
anything on
I'd
the
have to
6 year.
consult the briefing below, but we certainly believe the court erred in dismissing the entire fraud claim at minimum because we get the 6 years, we think, from the filing of the original complaint.
I'm not going to argue with that, but I'm not going to argue.
I understand,
with you
Your
about
Honor.
that. But if you didn't present that to Supreme Court and Supreme Court writes you focused on the second half, the discovery rule, that implicitly indicates that, okay, maybe your adversary is correct. That it's 3 years. 3 years doesn't matter if it's fraud or whatever. It's 3 years all the way around.
No, Your Honor. The
Okay,
fraud
got
claim
it.
is not displaced by
Thank
the
you.
UCC. Thank you. Thank you, Your Honors.
All right. See, I told everybody we read everything. Okay, Mazurka versus 201 Water Street.
Good afternoon, Your Honors. May it please the court. James O'Connor for third-party defendant employer Apex Restoration. The record in this case consists of 1,055 pages, and the respondent's brief is 18 pages. Nowhere in that 1,073 pages is any proof offered in admissible format that the plaintiff sustained a grave injury as defined by workers' compensation law
That's
section.
not the issue here, is it? I mean, the issue here is whether or not your motion for summary judgment was timely. So you.
I just think it's important to point it out.
I understand, but I'd really like you to focus on what the legal issue
Yes,
is before
and the
us, 'cause
issue
that's
is-
all we can focus on.
Thank you, Your Honor. And the issue is whether or not the motion was timely. I can count and I can read, and obviously the motion was untimely as it relates to the order of the court setting forth.
What was the good cause?
That's right, that's right. The court doesn't need me to recognize that litigation is messy, it's not always linear, and that's why the court, in responding to the strict rules of Brill, allow litigants to show good cause as to why a motion is late. In this instance, there were two previous court orders requiring the third-party
What was the
plaintiff
good cause?
defendant
Let's get to that. Let's
to
focus.
give us the IME. This court has held in sleds.
Yeah, but
What
hang on a
was the
second.
good cause?
No, but hang on a second. When you're relying on the IME, I got in my notes here that wasn't even used. That wasn't even used.
Well, it was exchanged 6 days,
but-
days before the motion was
But
made.
if you were relying on the IME as your basis as good cause, saying that that's why we were delayed because we were waiting for the IME, and then ultimately you don't use the IME, that kind of.
Waited 8 months, and that's pointed out by Judge Getz in his decision, but we
Yes.
waited 8 months to get the IME
Okay, I'm not.
after the note of issue is filed.
Got it. But did you use the IME later on? Yes or no?
No, no. we
Okay,
did not.
there we go.
We did not. But we were faced
would've
with a
been better if you
situation.
had-
We're
you know
faced
what?
with a situation where there were two prior court orders requiring them to exchange the IME. We had submitted, as the record reflects.
Counsel, we're not, I don't think, at least I'm not arguing with you about that. And you know what? That's a great argument saying we're waiting for the IME. And it would even be a slam dunk if you use the IME later on, saying, okay, see, there you go, we used the IME, but you didn't.
But it's not unreasonable for us to be saying, listen,
Well,
we
then
need
it
the
becomes
IME
an
because
abuse.
This court has held in sleds, and it's best practice, I think, to suggest that it's not best practice to submit a motion asking for summary judgment on no grave injury and have no medical proof submitted in
You
support.
didn't use it. Am I missing something
It
here?
was exchanged,
When,
as the record, I think,
The record speaks
reflects.
for itself. This is an abuse of discretion by Supreme Court, whether or not it did the right thing, right?
I'm not saying it's an abuse of discretion. I'm saying it's reasonable. It's reasonable to argue when viewing the equities, when viewing not only the equities, but the idea that we have made other efforts in this case to introduce this idea that there is no grave injury.
let me just say this. What did you use on your prima facie to show no grave injury?
Plaintiff's proof that he had submitted in support of his case. The plaintiff's
So
bill of particulars-
how could you possibly say that you admit you could have made your prima facie without it? And in fact, you did make your prima
Well, we
facie.
had to. We had no option. We were forced with the idea that
Wait,
we
you
had
had
made a motion to
time.
the court to extend the time to file a motion for summary judgment while we waited for this IME that was elusive and not being produced. We asked the court for more time to file our summary judgment. They denied it. We had no option but to make the motion with what we had. It's not best practice. It's recognized as this court that a motion for summary judgment on a non-grave injury issue in SLEDs might be considered premature.
Didn't you wait 3 months after having finally received the IMEs?
No, I don't think
No?
so. No. I
Really?
think it was a much shorter time frame than
How
that.
much shorter?
I think it was 6 days after we received the IME on February 22nd that we moved for summary judgment. So, again, defendant third-party plaintiffs suggest in their brief that based solely upon the evidence provided prior to the motion deadline, that we could have made the motion timely. It ignores the fact that it is not best practice. It is not preferred, and it has been held by this court that we shouldn't practice in that fashion. We should produce medical proof when we're arguing that there is no grave injury. And again, when viewing the equities, when viewing the idea of judicial economy and the whole purpose of summary judgment practice
But then
to
you-
limit issues.
I don't have a problem with the idea that you should have used medical proof, but you didn't use the only medical proof that you were waiting for, the IME,
It was
right?
exchanged in crossing in an email 6 days before we made the motion.
All right, thank you.
Thank you, Your Honor.
Good afternoon. May I please the court? I represent the respondents on this appeal, and we submit that the lower court properly exercised its discretion when it found that Apex failed to show good cause for its delay in filing the second motion for summary judgment almost 1 year after plaintiff filed its note of issue, and that Apex failed to provide satisfactory explanation as required pursuant to the Brill standard to identify or to explain how what was the cause of the delay of filing of the summary judgment motion. In its decision, the lower court correctly found that Apex failed to demonstrate good cause for the delay. It specifically noted that although Apex...
Also, I just want to iron something out with you, because counsel kept saying that their delay was 6 days. My understanding is that it's 106 days.
106 days, if I may provide a timeline, which I actually wrote down, of all the motion practice.
So they filed their their second summary judgment motion on June 2nd, 2022.
Right.
And they received the IME on February 22nd,
That's right.
2022.
That's right.
It's
In
106, not 6.
4 months later, they filed the second motion for summary judgment, and they filed the first cross motion for summary judgment in November, which was also 2 months after the actual deadline for filing of summary judgment, but they couched this as a cross motion, which the court accepted and even recently ruled on that very cross motion. We had oral argument in the lower court, so that court accepted the first delay, but the second delayed motion, the court denied the motion for a very reason, that Apex failed to provide satisfactory explanation why it waited 106 days to file its second motion for summary judgment, and it didn't move for having had a chance to move for summary judgment or on its common law and contribution claims back in November. Within its cross motion, it failed to do so.
So
It had
at the
all
time, let me
available.
ask you this, at the time it made its cross motion for summary judgment, did it move at that time to extend its deadline for filing
No.
summary judgment?
It did not. It may, actually, 2 months later.
So you would assume at the time it made a cross motion, it knew it didn't have the document then, right? And didn't make any motion at that point.
No, it made actually the first, it made motion for, to move for leave to conduct additional IME and to extend its time to file second summary judgment back in January, on January 5th, 2022.
Okay.
That's it?
That's it.
Oh, thank you.
Just in review.
Counsel, you filed your summary judgment that we're talking about, that motion on June 2nd of 2022?
The second motion, the
The
first
second motion, the one that you said you were waiting for the IMEs for.
The first motion, which.
Nope, the one that you said you were waiting for the IMEs to file. Did you file
there was
that
a-
on June 2nd of 2022?
Yes, Your Honor.
And when did you receive the IMEs?
February 22nd.
So it wasn't 6 days in response to the question that I initially asked
It
you.
was another motion that is not subject to this record where we were seeking the court for leave to extend to file the summary judgment motion and also to compel or actually request our own IMEs.
The timeline is not making sense to me. I asked you a question regarding when you received the IMEs that you claim you were waiting for.
February 22nd.
Right. And I said to you, did you not file your motion well after you received the IMEs, 30 days after?
Second motion, yes. Yes, Your Honor.
And you said, no, I filed it 6 days later.
First motion that we filed 6 days earlier, 6 days before that was to extend the time to file a note of issue and to conduct our own IMEs because we weren't able to get theirs. We offered at one point to share the IMEs with them, and they would, it would just.
The bottom line is that when you made your motion for leave to conduct additional independent and for an extension on January 5th, 2022, the court there, unless I'm reading my notes wrong, the court denied your motion to extend, right, without prejudice to filing another motion, your second motion, which is in June of 2022, showing good cause. And at that point, as like my colleague points out, if you made that motion, the second one, on June 22nd, your good cause would have been to attach the IME that you got 106 days earlier.
I concede that, Your Honor.
And you concede.
I do.
Great.
But I guess the point is, the whole point of summary judgment practice, and we have tried 3 times to bring this to the court's attention, is to narrow issues in a case. Nowhere at any time has there ever been anybody who's come forward to say plaintiff sustained a grave injury here.
Yeah, but that is true in every case. I mean, Brill says that if that were it, then we would allow every late summary judgment motion that had any merit, right? The merits of the motion don't mean anything in that context. It's just the good cause. Even if you have a meritorious motion, according to Brill, if you don't have good cause, you're out. And there's nothing there's nothing we can do. That's the law under Brill, right?
Thank you, Your Honor.
Okay, thank you. Oh, yes, next case is Wagner Associates versus PFNY. Justice Kismer is recused on this case, and she promised to come back.
Good afternoon, Your Honors. May it please the court. My name is Joaquin Escudero of Morrison Cohen for appellants. Your Honors, this is an appeal of a motion for summary judgment, and as such, the central question here is whether there is a triable issue of fact.
Wait a minute. So the question for us is, was there a repudiation? Was there a default? What happened? I mean, you were accepting rent, so there wasn't really technically a default, right?
Well, there was a no waiver provision in the lease, Your Honor.
We get the no waiver provision, but ultimately, if you want the relief that you're seeking, you have to at least serve notice of a default for the cure, right? I mean, they were paying up until a certain point when they finally realized, hey, wait a minute, you took over the premises, and we can't use it anymore. That's when they stopped paying you the rent, although it wasn't the exact rent that you were looking for.
Well, actually, Your Honor, a couple of things. Number one is there was actually no provision in the, as we note in our papers, there's no provision in the lease that requires us to serve a notice of default and to cure except as a prelude to trying to terminate the lease, which is undisputed. We did not try to do until 2018. So during the relevant time period, we didn't try to do that. So there was no requirement on us to serve a notice of default.
But you're saying that they repudiated the agreement, right? There was a repudiation on the tenant's part.
Correct. They violated the
So
agreement.
how is there repudiation if you accept their rent?
Because there's a no waiver provision. There's a provision that specifically says in the lease that
But
even
that doesn't get you out of the fact that you are accepting rent. That raises an issue of fact. You can say, in my mind, and actually, right, I think we both agree that the no waiver provision is for you to claim rent back way back when you do call the default. It's not for you to say, at the time I called the default, you didn't pay rent, therefore I can prove as a matter of law that you repudiated the lease. That is not what the law says.
Well, Your Honor, I would say that there are numerous cases that uphold these kind of no waiver provisions.
Oh, I agree. It's no waiver. You don't waive your defaults simply by not calling them. There's no equitable estoppel, but that's not the same as saying the plaintiff repudiated the lease by not paying the full rent. That's a completely different thing. And the fact that you have a no waiver clause doesn't mean as a matter of law repudiation. I don't think you could show me a case that says that. So in this case, the plaintiff puts in evidence that says, I am trying to get a subtenant, I'm paying the rent, the landlord's trying to get a subtenant. Those facts lead to at least an issue of fact as to whether or not I've repudiated, right?
Well, no, I would.
And what do you say to that?
I would say that, you know, the case law is clear that when you have a continuing breach or continuing repudiation, it renews the landlord's ability to either terminate, or it renews the ability of the landlord to forego its own obligation. So it wasn't just one breach here we're talking about, one isolated breach that happened and then months went by, nothing happened. They continued underpaying rent, and most importantly, they continued daily violating the lease by not maintaining their business operations. That was in the lease, and they violated that daily. They never got written consent to do that. Now, one thing I will say, though, is that...
So you still treated them as tenants, right? I mean, that's the overall gist of it, right? They were still tenants under the lease.
They were not. They were a tenant under the lease, but they were not a tenant in good standing. We had a no waiver provision, and they kept violating the lease.
I'm not disputing about the no waiver provision. I'm just in terms of your relationship, right? There was still an ongoing landlord-tenant relationship.
The lease
right?
was not terminated.
So yeah, the lease was not terminated.
Correct.
But then you're taking the position also, the lease is not terminated, but it also we're treating them as repudiating the contract. You can't have it both ways. It's one or the other, right? It's either they repudiated or they did.
Well, no, the key thing here, though, is that the non-waiver provision combined with the continued breaches of repudiation is what makes this different. Yes, I would agree.
So how do you deal with the fact that they are paying you rent, that you are accepting rent, that their witness testified that you and them both are looking for a subtenant of the space, right? How do you contend with those factual showings that the lease was not repudiated? Because I don't agree with you, the mere fact of a no waiver clause means automatic repudiation. I don't agree that that's true. I think that a landlord can choose to waive. You have a clause in your lease that says it's not automatic. I can go back and call it, which you eventually did. So let me just ask you about the two factual issues the tenant raises. What do you say to those?
Again, we would say that it's irrelevant in as much as there were continuing breaches and there was a no waiver provision, and those continuing breaches kept renewing the landlord's ability to either terminate the lease or forego its obligation.
But you are exactly right. You could terminate, but you're saying they repudiated. That is a different legal concept. That's what I'm having a dispute with you about.
Understood, Your Honor. Look, if I may just say, not to switch the topic too much, but our summary judgment motion, the entire motion, that is one of the grounds on which we move to summary judgment. It's not the only one, and you can put aside repudiation if you don't accept that argument, because of the issue here is their claim for eviction, right? They claim that there was an eviction in December 2017. The undisputed facts show that there was no eviction because there was a provision in the lease that allowed the landlord to go in and perform the work, and the case law of this court is clear throughout the years that when you have a provision in a lease that authorizes a landlord to go in and perform the work, that there is no wrongfulness sufficient to constitute an eviction. You cannot have an eviction. And in addition, and specifically the Section 13 of the lease here says that damages were restricted to where the tenant's access to the premise or operation of the business was adversely or materially affected. Again, it's undisputed that by the time they claimed breach, they had already ceased operations for 1 year, and they had access throughout, even during the time, the few days where they found the front door locked, they still accessed the premise. In fact, they accessed the premise that very day to take the pictures that they claimed were the eviction. So on that basis...
You have rebuttal time. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Joseph Wiener on behalf of the tenant and guarantor respondents. I think the Court has already hit
the point is that I'm trying to get is that if they're deeming you that you repudiated the contract, how's that so when you're still paying the rent and they're accepting it? There's no repudiation. I mean, my understanding of repudiation is that you either, as the landlord, as the non-repudiating party, you could do two things. One, treat it the ultimate breach, terminate and sue right there. Or you could just, you know what, forget it. We'll just keep taking the money. So there's been no repudiation, right?
I absolutely agree with that.
How does the non-waiver clause factor into that, though?
I think the non-waiver clause is a red herring. And we don't dispute that the landlord could have served a notice to cure months and months later saying...
Did they have an obligation to serve?
Absolutely. The lease...
Based on the lease?
The lease says in the event of a non-payment of any rent, cessation of business operations, the landlord has to serve a notice to cure and give us a 30-day cure period, and that just never happened here. So the tenant was deprived of a basic protection under the lease. So it's undisputed that we gave notice to the landlord that we were ceasing active business operations. That's what happened in December of 2016.
That in itself, it could be a clear repudiation right there. If they treat it as such, that's it, you're done. You've breached the lease because, I mean, arguably, you can say the lease says you cease operations. The way you do that is say we send them a letter saying we're ceasing operations. They don't have to serve you a notice of default. They could just treat that as a repudiation, stop accepting the rent, and sue you.
I don't think that's right, Your Honor. I think they still would have had to serve a notice to cure because the lease specifically says in two...
They would be in better shape other than the facts that we have here.
Sure, yes, but those are not...
Because repudiation is your conduct, not their conduct, right? So you have to show that your conduct is inconsistent with repudiation, because the fact is, if all that happened was that you stopped paying rent and you stopped being at a gym, that would be pretty clear evidence that you repudiated. But you argue that the evidence shows that you didn't repudiate. It doesn't matter what the landlord does, it matters what you do. And you argued, we told them we were going in, we were paying the rent, we were trying to get a subtenant, we did everything that shows that we weren't repudiating the lease. Is that
absolutely
correct?
Correct.
All right,
it's a twofold argument. I mean, I'm responding to the court's question. Our first argument we make is that there was no repudiation. We told the landlord what was happening. The landlord didn't object. We kept paying rent. We kept business materials, client files, equipment in the space. We were in touch with the landlord about finding a subtenant. We don't think there was a repudiation, which requires an unequivocal intent not to perform under the contract, and the evidence shows we could have resumed operations in a matter of days, but for the landlord's conduct. Even if the court disagrees, the landlord has to make an election, which just didn't happen here. It accepted all of the...
It really is all about your conduct. Repudiation, it's you, what you did or didn't do. So, but let me just ask, the landlord says that it has a right to enter the lease. It did what it was doing facade, and the lease does give it the right to enter, so how is it an eviction?
The lease does not give the landlord, excuse me, the right to take the steps that it took here. What's missing from the landlord's papers here, which I think is pretty striking, is the landlord is required to give prior written notice, and that access is only allowed either in an emergency, which is, nobody says there was an emergency here, or at other reasonable times. And those three words are missing through ellipses from the landlord's papers here. I think it's boggles the mind to say that other reasonable times includes months and months of setting up operations for an entire building project, not even for work in our space, for some indeterminate period of time to take over the space. This is clearly intended for limited repairs, to go in, get access, something needs to happen, there's written notice, and notice here is also a sharply disputed fact issue. There's no evidence that we were ever given notice of what happened.
You know what?
Let alone
It just
given
dawned on
consent.
me. Their argument about repudiation is to permit them to get around the eviction problem that you're raising here. Because if they treat this as a repudiation, they can go into that premises right off the bat because you're no longer, the lease is terminated.
Of course, and what is completely inconsistent with the argument here is that the landlord served a notice to cure in January of 2018. After we said we're not paying rent anymore because of the eviction, and as the lower court held, why in the world would you do that if you're claiming they repudiated 14 months earlier such that you were allowed to go in and retake possession in why would you serve a notice to cure in 2018 if you said you were allowed to go back in 2017? Then they served a notice of dispossession in September of 2018. It's completely inconsistent with
So with respect to the notice issue, the landlord says that they told you they were doing this facade work, and there's evidence in the record that you understood it. But what I want to ask you about is the part of that section 13 that says access to the premises shall not adversely or materially be affected. Your access shall not be materially or adversely affected by the repairs. And it's your argument that having homeless people sleep in the premises, breaking all the windows, that materially affected your ability to use your premises. I'm sure you couldn't show it to prospective subtenants.
Absolutely.
Is that is your argument that raises an issue of fact, correct?
Absolutely. I mean, there are additional facts. I mean, the testimony shows we could have resumed operations in a matter of days. That provision that Your Honor is referring to still requires prior written notice, reasonable times, and that specific language also of the lease, it only refers to work in the premises. And the landlord here concedes there was no work in the premise. This was a building project. There was no work in the premises. So that's what that's talking about. I can bring equipment in, and if I'm doing work in the premises, sure, I can bring equipment in. I may need to make some repairs, and if I adversely affect your business, that's reasonable. Then you can't claim a rent abatement or claim an eviction here. But that's just not what happened here.
Your suit against the landlord, I mean, you commenced an action to the landlord. One of the things is the eviction argument, right? That you have been evicted under the lease, right? And which
There are two actions. The tenant commenced one action claiming an eviction, and there's a separate action by
the landlord commenced against the guarantor.
against the guarantor,
Right.
correct.
But your main action is that's where you assert the eviction argument or the eviction theory of how you can stave off or how there's, like, you're entitled
The landlord concedes that there's no claim under the guarantee.
Right,
Mr. Escobar
everything
mentions-
rests and falls on this act, on your
I agree,
plaintiff's action,
yes.
right? And then in response to that, they said, oh, you've repudiated. I got it, thank you.
Correct. Thank you, Your Honors.
Your Honors, I'd just like to, I mean, I don't have
Let me
time.
ask you this question. It dawned on me as we're having this argument, that your whole repudiation argument is to protect you from, or at least thwart or rebut, or have a defense of the eviction claim. Because if you go and say the no waiver, and that there's a repudiation, that goes all the way back to the day one when they said they're ceasing operations. So any claim of eviction goes out the window, because according to you, they repudiated, lease terminate, what eviction can exist? Is that what's going on here?
Well, I mean, in effect,
That looks like what it sounds like, right?
in effect, yes, because it's
Ah,
not just,
got
it's
it
not
now.
just the original, again, it's not just the original day they ceased operations. They never resumed operations.
Right.
So they violated the lease basically
understand.
every single
I got
day.
it. Yeah.
I just want to make a couple of quick.
At some point, that the light bulb does go off.
Why serve the notice and the cure if it was repudiated?
I'm sorry, say that again?
Why serve the notice to cure if you think that there was repudiation before then?
Well, this is the point I was getting to, Your Honor. I mean, I don't have time to read it entirely, but it's in our brief. Section 17 of the lease, again, it does not require a notice of default and to cure simply upon the occurrence of a default. It requires.
That's not, you're not answering my colleague's question. Why'd you serve it then? You
I'm
didn't have
getting to that.
just get to it. You're running out of time.
We served it at that time because when we did serve it eventually in 2018, we did then intend to terminate the lease at that point, and that's effectively what we did.
You intended to terminate a lease that was repudiated?
Correct. We wanted to terminate the lease at that point.
No, you're dotting, what happened is you're dotting your I's and crossing your T's to solidify the fact that there was a repudiation and backdating it that all the way to the point where they tell you there was ceasing operation. And at the same time, relying on the fact that there was a no waiver clause that allows us to do this, you know, a little later in time or way down the road, and it goes all the way back to num pro tunc, to the beginning of when they said they were going to cease operations. I got it.
Again, I just want to make one last point, Your Honors. Again, if you don't accept the repudiation argument, that is not necessary to hold in landlord's favor here.
Okay, thank you.
There is the provision of the lease clearly
it.
allows us
Thank you.
to go into the premises. Thank you.
Thank you. Pifu versus Daquan Johnson. Back. It's nice to have you back.
Thank you.
Good afternoon. May it please the court, Legal Aid Society by Everett Hopkins for Daquan Johnson. Your Honor, this court should vacate the SCI plea because it was jurisdictionally defective. Additionally, this court should reduce Mr. Johnson's sentence in the interest of justice because it's excessive. To my first point regarding the SCI plea, Your Honor, what this case is really about is two different crimes. There's a crime dated January 21st and a felony complaint.
Is it about two different crimes or just a typo about a date?
I'm sorry?
Is it about two different crimes or about a typo regarding a date?
Well, the case law shows that the date is the crime, Your Honor. It's part of the crime.
Oh,
it's part
just
of the
the
conduct.
date?
It is all tied into one. So.
Well, the date is not an element of the crime, is it?
It is, Your Honor. And if you look at People v. Walker and People v. Melvin, those cases actually are the exact same facts we have here. In those cases, the court said that because the felony complaint and
Wait,
waiver,
the date is an element of the crime?
the
It's in the penal law section listed as an element?
No, Your Honors, but what the case law indicates is that if the date in the felony complaint and the waiver of indictment are not the same in the SCI as the date of the offense, it is two different crimes. Now, People v. Walker.
No, are you referring to the case that multiple rapes were charged on one date?
I'm sorry, Your Honor?
Are you referring to the case where multiple rapes were charged on one date? Is that the case you're referring to in terms of the mistaken date?
No, I believe. I think one of the cases, maybe Melvin, is that. But if you look at People v. Walker, they're both saying the same exact thing, and it's not necessarily about that type of crime. What I want to emphasize, Your Honors, is that simply because the penal law is the same in all the instruments does not mean that it's the same crime. Right? The crime depends on the conduct. And
Was there anything in the record to suggest that during the time of the allocution on the SCI that there was a different crime being referenced, a different crime from that referenced in the complaint?
There was no discussion of that during the plea allocution, Your Honor, to answer your question directly. However, if you look at People v. Melvin and People v. Walker, the date of the crime matters because that is all tied into part of the conduct. Now, to your point about it being non-elemental, which respondent does rely on, that case is People v. Milton, which is a Court of Appeals case. Now, they discuss what factual information not elemental to a crime is. In that case, the defendant had raised an appeal because the names of the complainants that were in the felony complaint were changed in the SCI. Now, the court said basically that, that's not a matter of change in crime or conduct. What that is just a change in perspective, which makes sense. And People v. Walker and People v. Melvin are the cases that I'm relying on because they actually cite to that case and agree with it. However, they're basically inferring that that is the conduct is part of the date. Right? And that makes sense, because if you think about it, Your Honors, you don't need a complainant's name to take a plea in the state of New York. But what you do need is a location where the crime happened for jurisdictional purposes, like if it happened in Manhattan or if it happened in Brooklyn. You also need a date as to when that conduct occurred. So those are all jurisdictional elements that are part of a plea, and that's why this case is distinguishable from Milton, because it's not just factual information about, who the crime was committed against, it's about the conduct itself, and that's what matters, and that's what makes this a jurisdictional defect. Additionally, Your Honors, if I can just touch on the excessive sentence argument, we're also asking that this sentence be reduced because, first of all, this is Mr. Johnson's first felony offense. He has no history of violence. There was no violence involved in these cases. There was no harm to the complainants. It should also be worth noting that.
But that was almost by chance that there was no harm to the complainant. I mean, there was some violence used in the charged crime, correct?
Well, there was a taking of property, Your Honors. I don't think there was any type of injuries such as bruises or anything like that to the
In
complainant.
the first incident, they pushed the elderly victim to the ground, right?
There was some pushing, yes, and there was a removal of property. But it's also worth noting that there's nothing indicating exactly what Mr. Johnson's conduct was in those instances because they were all accomplices involved. So while he was there at the scene, while the property was being removed and he likely left with the accomplices, it's not exactly clear as to whether he was the one to remove the property or to touch the complainant in any way. So I'm not negating his guilt in that way, but I'm just saying it's relevant to this court's consideration as to whether they want to reduce his sentence or not.
Counsel, do you have the cite to People versus Melvin?
I'm sorry?
The cite to People versus Melvin.
People v. Melvin,
Sorry, I don't
I
have
think
it
I
right
do, yes. Yes, 21 NY 3D 133, 2017.
1, 2, 3, thank you.
Milton, you said, or Melvin?
Melvin, People versus Melvin.
Oh, I'm sorry. No, Your Honor, I can get that for you on rebuttal, though.
Thank you.
Okay. Lastly, with regards to his
Counsel,
sentence.
let me just ask you, do you agree that if his appeal waiver is, he waived his right to appeal, so if this isn't a jurisdictional defect, he's waived it with his appeal waiver,
It's non-jurisdictional, Your Honor, but obviously our position is that it is a
Right,
jurisdictional
okay.
defect. Yes.
All right, and what about People versus Stewart?
I'm sorry, Your Honor?
What about People versus Stewart?
I'm not familiar with that matter, Your Honor.
2022, the Second Department said that this very error was non-jurisdictional because it was a product, because there were no other circumstances surrounding which could have pointed to a different crime or offense, right?
Well, that's essentially what People v. Walker is saying, that the conduct involved is so vastly, there's no possible way that it could be related to the same crime that was involved in the felony complaint because the dates are so different. The felony complaint lists the date of offense as January 21st. Now, the SCI here dates it as March 1st. So there's no possible way that those crimes can be.
But there's nothing to indicate that the defendant was pleading to something that was not charged in the felony complaint, right?
The date, Your Honor. The date is the exact reason.
Right, but I guess what you're missing is that this could be just an error. It's different when there's a scrivener's error and they put the wrong date, right? As opposed to there was a robbery on this date as well, and now we're charging you with that one despite the fact it's not in the felony complaint. That's not this case.
Well, two things, Your Honor. The Walker court explicitly rejected that argument that it's not a typographical error. The second thing is that, the second thing is...
Rejected what? That errors don't exist? That they don't happen?
No, but in that case, which is the same facts that we have here, that's simply because the dates were so different that there's no possible way that it could be based on the same conduct. The date is a part of the conduct. You have to be able to allocate and to charge someone with the date of the offense that it happened. And that's the whole purpose of 19520, because it makes it so that you can't be charged in the SCI with a crime that was never charged in the held before grand jury action. So that's what we have here, and that's exactly what the Walker court said.
Okay, thank you.
Thank you.
May it please the court. Good afternoon, Your Honors. Christian Rose for the People.
Counsel, is he right? Just jump right into it. Is he
No,
right?
he's not right, Your Honor. And
Why not? Tell us why not.
Well, especially with regards to the location, date, and time not being elements of the crime, that's exactly what Lang and Wally said, the Court of Appeals said in 2020 are not elements of the crime. So those came after Milton, they came after Walker, and so did People versus Jackson, which was just decided, well, not earlier, in 2023, that People versus Jackson said that a variance in the location and date of a robbery, I think it was 2 days in a different bank location, were not elements of the crime, and therefore the error was non-jurisdictional. I think Stewart was about a month difference in the date. Maybe if this case were in the 4th Department in 2017, before these Courts of Appeals cases, before Jackson, might be different, but it's become clear since then that these are just non-jurisdictional errors in the SCIs. As for defendant's excessive sentence claim, defendant did validly waive his right to appeal, and in any event, the near minimum sentence for these 2 robberies, which included one done at knife point and one where the defendant and 2 accomplices assaulted a man in an elevator, the sentence was fair and appropriate. I'd just like to quickly push back on the idea that there was no history of violence for defendant. These were 2 violent robberies, even though nobody was thankfully injured apparently. But defendant also already had 2 prior misdemeanor convictions for third-degree assault, one which involved a recommendation for the batterers program, which he apparently did not complete. And he also had 2 unindicted robberies that were open at the time of this case, as we point out in our briefs. So for those reasons, unless there are any questions, we ask that Your Honors affirm.
Thank you.
To your
So,
question,
counsel,
Your Honor.
I looked at People versus Melvin. It's a 4th Department case, and it's not really on 4s. And this is what my colleagues were pointing out. There are 2 dates involved there: December 3rd day and the December 23rd day. Both dates having separate crimes being committed by the defendant here. And there was the 4th Department said that there was a jurisdictional defect there because he didn't know which one he was pleading to, so there was a little bit of an overlap.
Right, but again, Your Honor.
Right, so this one, I don't think this one, we have that kind of scenario, right? We have a March versus whatever date, I forget the date, that's crime. It's one crime.
Well, it's
We're not
the
dealing
same.
with multiple crimes.
Again, Your Honor, remember I said, simply because it's the same penal law does not mean that he's charged with the same crime or conduct. So that's the whole point of
I
195.
know, I understand, but you can't, unless I misheard you, you were relying heavily on People versus Melvin to say that this is wrong.
Right, and Walker.
Okay, all right, if I look up Walker, it's probably gonna say the same thing, right?
It says
Okay.
similar.
Thank you.
It's similar, Your Honor. But again, simply being charged with the same penal, that's what these cases all stand for. Simply being charged with the penal law in all the instruments is not exactly the crime. Now, my respondent does bring up this case of Jackson. What I would point out is that it's more likely that this court, when deciding Jackson, determined that it was all one crime and not 2 crimes, simply because the date in the felony complaint was March 8th, and in the SCI they said on or about March 10th. So reasonably, it's likely that that was all talking about the same crime or the same conduct. With regards to any violent history, Your Honors, again, Mr. Johnson has no felony record, therefore, before this, and he had no history of violence before that. So based on everything, Your Honors, I would ask that you reduce his sentence and find the SCI jurisdictionally effective.
Thank you. Abdul Fatal versus Rivervale Corporation.
Your Honors, my name's John Daly, of counsel to the Fitzgerald Law Firm, attorneys for Plaintiff Appellant Abdul Fattah. Plaintiff respectfully submits that we would like to rely on our opening and reply briefs and only make one point on argument today, and that is about and relating to the chronic understaffing that existed at Co-op City. Defendants had a plan of 22 posts for Tour 3. I just want to step back and say at Co-op City, there are 3 tours per day. Each tour is 8 hours long, from 8 in the morning to 4 p.m., to 4 p.m. to midnight, and from midnight to the morning. Our tour is Tour 3, and we have sworn...
Counsel, isn't it fair to say that even if we were to agree that they had chronic understaffing, even if they were fully staffed that day, isn't it just speculation to say that that would have thwarted this clear, intentional attempted murder of your client?
Your Honor, that's a good question, and I appreciate it. We believe the Scurry case from the Court of Appeals addresses that intentional attack upon a plaintiff.
But in Scurry, there was a very specific absence of, in that case, the exterior door locks didn't lock. It's a very different kind of failure to provide security then in this case.
Well, Your Honor, what the emphasis of Scurry, as we advance in our brief, is that an intentional attack no longer does away with proximate cause. You have to show more than the mere fact that what we're dealing with here is an intentional attack. We were dealing with, argued by the defendants, an intentional attack, and they argue that evaporates, takes away proximate cause. And that's, the Scurry case tells us that's not the case. It doesn't matter that it was an intentional attack. That does not take away proximate causation. That's very clear from the Court of Appeals on the Scurry case. And what our contention is, Judge, is that by not providing all these security things, if there had been full staffing, that would have acted as a deterrent.
But the law is very different in terms of a landlord's obligation to provide exterior locking doors and the obligation to provide security over a large area of public land and public parts of buildings. So I have trouble understanding why it is that Scurry is what you're relying on, because the duty
we're only
is very,
relying on.
Excuse me, the duty in that case is far more clear than the duty here, isn't it?
I don't believe so, Judge, because here the Co-op City undertook an obligation that they didn't have to. They undertook to provide policing for the entire.
You know, that's interesting that you say that, because you say that in your briefs, and then I kept looking up the record sites for your support for that, and none of them supported that. I didn't see anything in the record that supported that Co-op City had undertaken to provide security on all of its property, whether it was in the buildings or not.
Well, Judge, the Levia case from this court itself talks about the duty that Co-op City undertook that extended to private walkways, all sorts of aspects of the property at Co-op City.
You're referring to Levio at 206 82nd 150?
Yes, Your Honor.
That doesn't exactly say that case. I looked at that case very carefully. I'm not so sure it backs up your point that Co-op City undertakes or is, undertakes the responsibility of securing everything outside of its premises.
In Levia, this court was very careful to outline all the number of officers, the number of this, the number of that, and it goes on to say on private walkways and public areas of Co-op City. And we combine that with the Nayland holding, Judge, where if a defendant undertakes an obligation to perform services, it doesn't have to, and then performs them negligently, and the plaintiff relies on it.
Nayland also talks about, on the flip side of that, the justification part. There's a justifiable reliance portion to that argument too, whether that
Yes, Judge, and we believe that our plaintiff does support the fact that he justifiably relied.
I'm baffled by what it is in Leva you're relying on, because the next to last paragraph begins, strong public policy considerations militate against imposing liability upon owners for incidents of criminality which occur on public walkways and are committed by persons over whom they have no control. Co-op City is an open community in an open society. What about that case are you relying on?
Where it says that their duty extends to all those areas.
That's actually not what it said. Okay.
All right, thank you. You have your brother time.
Seems to me said opposite.
Good afternoon, Your Honors. I represent defendants River Bay, Marion Scott Real Estate, and Co-op City Department of Public Safety. Plaintiff's position here is untenable. Summary judgment was properly granted.
Counsel, I have a
Even
question.
if you, yeah.
What the record seems to show is that your client created 22 security posts and had a plan to provide security in each of those 22 security posts, but on the night in question, they only provided 13 peace officers to cover all of those posts. Why isn't that a breach?
Well, there were more than that. There was, for the particular area, we have to focus on 140, where this actually occurred. And there were 2 of the security guards whose rotation would come in there. They also had the mobile vehicle that would go through there. And
Would you agree that
and
they
minimal
didn't
there.
have the number of people necessary to staff all of the posts that they had created?
I would not agree with that, because the Co-op City had a variety of things that they were doing. And then, in fact, in the area where we're talking about, even witnesses were there after, they said it was a very well-lighted area. And everything that plaintiff starts talking about, even when it had to do with, he didn't rely on
So
that,
let me
even
ask you in that way, is there anything in the it's a leased community, right? A leased community.
Yeah.
Is there anything in the lease that says that that particular guard station has to be manned at any time during the day?
There's no specific thing about that. And he is not a, he was not a
So he
tenant
doesn't
from
have
that building, but
right,
no,
okay,
it
so
wasn't.
so he's just someone from the public, but the person who lived in that building wouldn't even have that, the right to have a contractual right to have a specific person in that booth at a particular time, correct?
Correct.
And there's nothing I mean, it's a nice plan, this is what we think we might do, but is there any requirement that in anywhere that booth be manned at any particular?
There is no requirement. In fact, it was there. It was there for other, it was, the vision would be that, it could be, maybe it could be used to give a certain vantage point to certain areas. But we have to remember that this plaintiff, when he's inconsistent in his testimony, which I've written in our papers. First, he was, he saw someone looking at him from the backseat of this car, but he's unconcerned. And then later in his affidavit, he's changing it. Oh, I never would have, walked here, da 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 da. And he also is saying there he wasn't allowed access through the back of the building. Well, thank goodness, no back of the building. We have a locked building.
And there's nothing. He enters into a public vestibule, right?
He's in a vestibule.
Anybody could have entered into
Yeah,
that.
and he had not,
the door was
even reached
locked.
the
There
buzzer,
was
and
no
there was a
broken lock.
doorman in the lobby.
Well, counsel, what about the argument that your client's on notice of the violent conditions, and that's why the safety measures were put in place, and that confers some sort of obligation on the
Well,
part of your
again,
client?
it's a matter of perspective. First of all, one of the things is, the NYPD did work in consort with them and preparing things. But as far as it's over a 2-mile area, 35 buildings, a variety of malls, this and that. To focus on this for this one building, this is where we have to be looking at what was going on there. There had not been a criminal attempted murder, a gun, not that building. And where this happened, he had just come in the vestibule. The other person was, outside just coming in, and so when he was trying to play with all these different elements from these different cases, and then creating from this hodgepodge something broader to expand obligations, where we did clearly meet our minimum securities and more by the fact that we're not just a locked door. We had the doorman in there. We have a lighted area.
Counsel, thank you.
Okay, thank you.
Thank you.
As to Levia, I cite 206 82nd at 154 to 155. CCPD maintains a security staff which provides policing, quote, for both the interior and exterior of Co-op City's building, as well as the sidewalks, walkway, and pathways. And I just point that out, that this court has looked at this problem before. Our contention here is we're not coming to you and saying Levia wins the case for us. We're coming here and saying that Nayland helps us win the case.
So then how do you distinguish Mahawashari, Wong, and like 4 other cases that are pretty much exactly like this case in which we dismissed?
Because, Judge, the plaintiff in none of those cases argued the nail-in, as we're arguing it, that the Co-op City defendant specifically undertook a duty to provide policing on all aspects of Co-op City and then was negligent in providing that policing. That's our contention here. And that is enough to support a duty. So there was a duty.
Where is that obligation to your plaintiff? Is it contractual?
It's not
So
contractual.
where is it? Based on what?
Based on the law of tort as defined by the Court of Appeals. in
No,
Maryland.
you have to have a duty. Where do you say?
The duty comes from they assumed an obligation that they didn't have to, just as in
What
Nail It.
duty do you think they assumed?
They assumed a duty to provide policing to the citizens,
And they did, right? They had police officers.
but they did it defectively, Judge. They did it defectively. They had 22 posts, and on the night of the shooting, only 13 were occupied. And that's negligent, Judge.
Thank you, counsel.
Thank you very much.
Churchill Owners versus Kent.
Good afternoon, Your Honors. John Farinacci for Appellant Jeffrey Kent. Your Honors, the Supreme Court below made a series of errors here, and it was based on a multifaceted.
Okay, let's get right to the heart of it. It's the guarantee that your client signed, right? That he was going to guarantee the maintenance payments.
That's
right?
correct.
And that his argument is that, wait a minute, this consent letter, or I forget what it was called, it was that he was supposed to be an occupant, the authorized occupant.
Successor upon his father's death, because
Right.
that was the gift.
Right, but the guarantee, unless I read the wrong guarantee, and that could be totally possible, the guarantee I saw or read did not have any provisions in there that it was dependent or conditioned on him being an authorized occupant, or that he was going to be the successor occupant of that apartment, or that he was actually going to have this apartment in any way. So how does he get around that argument then about him being personally liable under the guarantee?
Because, Your Honor, the guarantee is not just a freestanding document. It doesn't consist in a vacuum.
Absolutely right, because the guarantee has to be backed up by something. It has to be commensurate with the transaction that went on.
Correct, and the transaction was the transfer of ownership to a trust in which my client was a remainder beneficiary, in which the consent letter had him specifically signing the guarantee as consideration for his occupancy.
Okay.
It says it clear as day, which the the Supreme Court, I'm elevating Her Honor to the Court of Appeals, but
thanks a lot.
That the Court of Appeals, that the Supreme Court just ignored. It's paragraph 5, paragraph 10 of the consent letter, and it clearly provides that
Consent to transfer?
there's an
Are you
undertaking.
talking about the consent to transfer?
Consent to transfer, which is a contract.
Yes.
And under it, in paragraph 10, it specifically says that the grantor and the authorized occupants undertake to give a guarantee.
But what is it?
Jeffrey
What
Kent-
is it that there's nothing in here that says that he is the authorized occupant?
But it is, because that
You're
section.
relying on that S, right?
I'm sorry?
You're relying on that S on authorized occupants as opposed to authorized
No.
occupant?
No, because
Well, you must be, because he's not named
there's
anywhere,
two
is he?
people. There's two people undertaking to giving the guarantee, right? They're both named. Roman Kent, who is the grantor, and Jeffrey Kent. The people who are undertaking to give it the guarantee, as specifically identified in that paragraph 10,
yes.
are the authorized occupant, the other authorized occupant, and the grantor. If they're right,
Where does it say that he is the other authorized occupant? That's what's missing.
No, but it isn't. It's right there, because
Where?
No, I don't
Not in
see it.
paragraph 10.
yes, the grantor of the trust and the authorized occupants, right,
Right.
of the apartment
Is there
undertaking and
anything
agree.
that delineates him as the authorized occupant other than that?
You have to read that sentence in conjunction with what follows it and with what comes
I'm
before.
asking you, is there any definition that says he is an authorized occupant? He is anywhere in any of those documents?
Yes,
Where?
paragraph 10.
Okay, that doesn't name him specifically.
It does because it talks about
Where
those two
is
people.
his name in paragraph 10?
In furtherance of this undertaking by the grantor and the authorized occupant, grantor and Jeffrey Kent, specifically named, shall deliver a guarantee of lease in a form and content acceptable to the corporation and its attorneys.
And that's what happened here. The guarantee, I'm looking at it right now, says that, because of this transaction, because the guarantee's got to be linked to a transaction, you can't have a blank guarantee. Just wait a second.
As an authorized occupant, it's stating what the consideration is.
Why bother asking a question if you're not going
I'm
to?
sorry, Your Honor.
So we all agree that a guarantee has to be linked up with a transaction, right? A guarantee can't
Correct.
be a standalone. So I'm looking at the guarantee here, and it talks about the trust. It talks about that's why the guarantee is being entered into, because of the trust and because the co-op wants this guarantee. And I'm reading here, it doesn't say, and also conditioned on the consent agreement, which then at that point, you may have a colorable argument saying, hey, listen, my client is an authorized occupant. For whatever it's worth, you can argue that, because then you're tying the guarantee to the consent agreement. I don't see, unless I totally misread this or can't read this because it's so small print, the consent agreement is roped into this.
Well, but Your Honor, the case law requires that where these documents are executed together in connection with the same transaction, they have to be read together. And there's no other writing, none in the record, that shows what the consideration for this guarantee was. The one thing that they pointed to, which was a mistaken belief by one of Churchill's associates that, actually one of Churchill's attorneys, that my client was a trustee, which he wasn't. And then they pivoted at the closing to, this is the reason why you're required to give the guarantee. It was what Roman Kent, and I want to make one other point, Judge. This isn't our only argument. We have an estoppel defense because the only people at the closing that day that gave an affidavit to the court below was
You can get that, you know what, you can get that on rebuttal.
Nobody gave, all right, thank you, Your Honor.
Hello, thank you.
Good afternoon, Paul Gruber, Goldstein for the plaintiff respondent. There's absolutely no document here that permits Jeffrey Kent to occupy this apartment without the
Authorized
consent of the
occupant.
cooperative.
So then what
that-
is
that-
the
that-
consideration for the guarantee?
The guarantee, that was not an argument that was raised in the court below. And there's nothing in the record that says that there was any issue with respect to that. Mr. Kent was certainly protective of his father. He probably wanted to make sure this thing went through. Mr. Kent, Jeffrey, was a beneficiary of this trust. Certainly we can assume that this transaction was structured because it was going to be an advantage to everybody involved, including Jeffrey.
I wouldn't concede the point about no consideration. The consideration here is that the co-op wasn't going to go through with this unless someone signs a guarantee.
That is true.
That's what the
true.
guarantee says.
That is true. We don't know about Mr. Kent, Roman Kent's finances at this point, but there was certainly an interest in everybody getting this deal done. The occupancy agreement, also executed at the time of closing, crystal clear. Robert Roman Kent was the only occupant. The president of the co-op attested in his affidavit, unrebutted, that the inclusion of the other authorized occupant language was erroneous, Scrivener's error. No one's contesting that. No one's contesting that the guarantee was signed. No one's contesting that the guarantee wasn't for a proper purpose. No one's contesting that there was a default in the maintenance. The argument in the court below, and to some extent here, was primarily, we didn't need a trustee to transfer the apartment. Fine, I accept that. Mr. Kent has done nothing to take title to this apartment. He has not paid it. And the lease is very clear on how he can do that. He has done nothing. The fact of the matter is that he executed a guarantee. The lack of the trustee, I'd like to point out, didn't hurt Mr. Kent. You know who it hurt? It hurt my client. Why? Because ideally this would have been a summary proceeding, except that I can't maintain a proceeding against a trust in the absence of a trustee.
Well, it also hurt him because it couldn't get resolved as well.
What?
It also hurt him because it couldn't get resolved as well.
Well, they're taking the position that Mr. Kent could have, that a trustee wasn't necessary to apply to transfer to the apartment.
But it's
That's
not as
true.
if he felt free to move in.
What?
It's not as if he felt free to move in at that
No,
point.
he wasn't free to move in. First of all, the proprietary lease was as Justice Owen pointed out, there's nothing in any of the documents that says that he could. The paragraph 10 argument is a stretch at best. Secondly, there was some dispute over whether he could access the apartment. Not necessarily move in, but access the apartment. And our client said, sure, but it has to be supervised. Why? Well, there's another beneficiary to that trust. We don't want to be caught in the middle of a dispute between the beneficiaries of trust as to what's in that apartment, who took what, who did this, who did that. Co-op has to protect itself. The co-op only really has two interests in the world. One, that its rules be followed, and two, that it's been paid. Mr. Kent has done neither.
Thank you.
Thank you.
Your Honor, what I'm hearing from respondents' argument is a very similar mistake that was made in the court below because there's a fundamental misunderstanding of trust law. You do not require a trustee, and counsel just conceded it, to transfer title to the property. The co-op's title vested by operation of law in Mr. Kent. There is no other beneficiary. That trust terminated. There's a successor trust.
Why wasn't, if that's the case, why wasn't he able to take title?
Because Churchill would not allow him because they took the untenable position that a successor trustee is required. Our brief fully goes over all of the reasons why that's not so. The Ziegler case,
That's being litigated right now, but that's being litigated in surrogate's court right now.
No, it isn't, Your Honor.
There's no surrogate's court action?
There's a surrogate's court proceeding for a successor trustee because there is successor trusts for the benefit of Mr. Kent's sister. Mr. Kent is the only remainder beneficiary of the trust in which his father was a income beneficiary, and the specific property, by operation of law, passed to Mr. Kent.
So then why don't you raise that in the surrogate's court, that you're entitled to the shares? Why not just bring an adversary proceeding in the surrogate's court and say, they're not transferring the property to me?
Because, Your Honor, then they're going to argue that, there's another case pending. We don't have to do that. In fact, the surrogate's court, in matter of law,
I mean, but you might think you don't. They think you do. And generally, when that happens, someone commences a litigation.
there is a proceeding pending for the appointment of successor trustees for different reasons. If a successor trustee were appointed, then we would.
I must be missing something in all of this because I'm only looking at a guarantee situation, right? I'm only going whether or not you're liable under the guarantee. The whole thing about whether or not you're entitled to the apartment, entitled to the shares, under the trust, that's all separate and apart from the guarantee, which says, I unconditionally will pay you because the co-op says, I'm not going to give you I'm not going to transfer the shares to the trust unless I get a guarantee.
2 quick points to answer your question. The Bank of Tokyo Mitsubishi case says, no, you must look at that guarantee not in a vacuum, but with the other documents that were executed that day.
Okay.
Secondly, the estoppel argument was completely ignored by the court. And if you look at the Court of Appeals case in Nassau Trust, you have extremely similar circumstances. You had a guarantor who was a defendant in mortgage foreclosure action based on non-payment. And that guarantor was in negotiations to stave off foreclosure proceedings to see if they could have a private sale. And there were oral representations made. What the court below made a mistake on is this defense is not an oral modification defense. It is an estoppel based on representations that were made. And in that case, the affidavit of the only party who had personal knowledge was the defendant, attested to the representations that were made. Just like Mr. Kent did in this case, his affidavit was completely rejected out of hand, and the court there said Lewis Imperato was the defendant in that case. The unrefuted allegations of Lewis Imperato's affidavit are sufficient.
Okay, counsel, we have enough. Thank you. You don't have to read the Thank you.
Tribal issues, in fact, my point is that that case is squarely on point. Summary judgment shouldn't have been granted. There was no opportunity to conduct discovery to get the depositions and
Thank you.
of those who were there. Thank you, Your Honor.
Thank you. Thomas versus Tribal Maintenance.
May it please the court. Good afternoon. My name is Ari Reiser from the law offices of Hardin, Cullum, McKean, and Paletto, representing non-party appellant Church of St. John's Visitation Parish. This matter arises out of a trip and fall accident that occurred on the exterior fire escape when plaintiff.
Counsel,
Yeah.
am I correct that your client didn't object to the amended complaint being pursued against it, correct? It didn't object to it becoming a defendant, right?
It did not object to becoming a defendant, and this issue is
So
not.
the issue that the trial court raised about you're not a proper defendant is not something you raised or ever sought.
Completely sua sponte, but it's not up for appeal. I don't want to shoot myself in the foot here. We're the only issue where, obviously, if we've been ruled to be a non-party to the action, that's good for us. We don't want to be a party to the action, and that's why we moved for summary judgment in the first place. However, and if plaintiff wanted to move, they could have filed a notice of appeal on that portion of the order. We just are filing an appeal on the portion of the order that denied summary judgment. That being said, right now we're a non-party to this action. They ruled that the amended complaint was a nullity. So we're a non-party to the action. So we have to show that we have standing to bring this appeal.
Let's get to the heart of it. Let's assume that the motion for summary judgment was properly denied, because I think Supreme Court said at the end, I'm going to deny it anyway. Why do you think that was in error?
Well, that was an error because, the first question that the court brought up was they said that the church did not prove sufficiently that it was the owner of the premises. Right. Okay, so granted, the lease and the lease extension did not name the Church of St. John Visitation Parish and named Roman Catholic Church of Visitation Parish. This, by the way, was also not brought up in either party's papers because it was obvious. But the testimonial evidence of Edward Newman and George Schiffriller established that the Roman Catholic Church and the Church of Visitation both merged. And they merged, and he testified to the extent that the merger did not affect the terms of the lease, page 303 of his testimony. There's no question, the merger document was provided. The merger document was provided early on in discovery. That's why plaintiff decided to discontinue against the Roman Catholic Church and add us as a party. They would never, if we didn't sufficiently prove ownership, they would never discontinue against the Roman Catholic Church. That wasn't at issue. This was brought up just by the trial court based on what it said on the lease. But the court failed to take into account the testimonial evidence. The deposition transcripts of both Edward Newman, the director of real estate for the Archdiocese, who managed the lease and the lease extensions, and also George Schiffriller, which is the church's business manager, who also testified that the church merged in approximately August of 2016. So they just brought up the issue out of thin air, essentially, that the church did not prove.
So let's assume that okay. So what about the fact that this happened on a fire escape that is attached to the exterior of the building?
Well, the fire escape is attached to the exterior wall, but
And the lease says that the landlord is responsible for the exterior of the building, correct?
He said the exterior of the building, but there's no case law that says that a fire escape is deemed just because it's attached to the exterior wall.
It's affixed. You can't remove it. So why is that not an issue of fact as to whether or not you have the responsibility for a non-movable affixture to the exterior of the building?
Well,
the lease doesn't say anywhere one way or the other, right?
The lease is silent on it, and when the lease is silent on something, we have to look to the extrinsic evidence. And the bottom line is the course of conduct of the parties show that that they did not believe that the church was responsible for the exteriors.
That kind of course of conduct, a classic question of fact that would preclude summary judgment?
Well, the case law provides that when the lease is silent on something, then that we should go to the extrinsic evidence. And the extrinsic evidence clearly shows that the course of conduct, namely that the AHRC, which is the tenant of the building, they were the one who paid immediately Triborough, our co-defendant in this action, to fix their staircase. And there was numerous testimony.
Well, that doesn't mean they thought it was their obligation. It may have meant they wanted to protect their employees. And then they would deal with who was responsible for it later.
Well, there was numerous testimony to the fact. There was Edward Newman, who managed the lease, and he testified that based on his interpretation of the lease, that it was not that the staircase was not, the fire escape was not included in the exterior wall. There's George Schiffriller, the church's manager, that testified that the fire escape, if they wanted to do any sort of maintenance or repairs, they didn't have to ask the church for permission. And of course, I think most importantly, the fact that immediately after this accident, AHRC, the tenant, immediately paid out of their own pocket and called Triborough to fix this to fix this fire escape. But more importantly, it leads to absurd results. Let's say
you think it's absurd to say that a landlord has the obligation to repair and affix fire escape on a building which requires the landlord to do exterior work?
Fair enough.
Repairs?
Well, not,
you think that's absurd?
Out of possession.
I think that makes sense.
You'll get that on rebuttal. You'll have time to think about.
An out-of-possession landlord. We're not talking about a landlord
here. Not taking my offer, taking a few minutes to think about that and respond. Thank you.
Good afternoon, Your Honors. May it please the court. Harper Smith for the plaintiff's respondents.
Counsel, following up on where we were, what in the record establishes a question of fact as to whether or not the obligation to repair the fire escape was covered unequivocally by the lease?
The part of the record is page 338, which is the provision of the lease itself, which states that the exterior walls of the premises are the obligation of the landlord to maintain.
Except this isn't the exterior wall. This is the fire escape, right? And the fire escape it doesn't say anything about the fire escape one way or the other. So how do you raise an issue of fact other than it's ambiguous? How do you show that it's the landlord's responsibility other than the lease?
The common law provides that a landlord has the responsibility to maintain its premises in a safe condition. Basso versus Miller, that specifically pertains to fire escapes that are affixed to the building.
No, but this is an out-of-possession landlord, right? We're not, argues, I pass that requirement on to the tenant. That's what the landlord says. And the landlord says every witness agrees with that. Do you agree with that?
It is the obligation of the tenant if the lease says so. In this case, we have a lease which is ambiguous. It refers to exterior walls. It does not refer to permanent fixtures.
Is there any witness that testified that it is the landlord's responsibility to do the repairs or to inspect?
The witnesses did not testify to that. The witnesses were simply relying on the lease itself, which is silent as to that.
Did the landlord testify that it had the obligation?
Lease manager testified that the lease provides that the exterior walls are the landlord's obligation. There was no testimony specifically about the fire escape because it's not mentioned specifically in the lease.
Right, but the question, right, we agree it's not mentioned. So I'm asking you, the two parties, you're the plaintiff, you're the person who fell. The two parties, the landlord and the tenant, do either of them think that the church had the responsibility? Do either of them testify that the church had the responsibility?
The tenant is not a party in this case, so we don't have any testimony from the tenant. Our only testimony is from the landlord, and of course they don't input on themselves the responsibility, but we have an ambiguous lease, and we've cited case law that where a term of the lease is ambiguous, there is a question of fact for the trier of fact as to whether it is the landlord's responsibility, and that is the situation here.
Okay.
Thank you, Your Honor.
Thank you.
Again, we're really coming back down to this one fact. Whether just because the fire escape is affixed to the wall, it's deemed an obligation under the lease.
But if that's ambiguous, then you don't get summary judgment.
Well, it's not ambiguous because none of the, again, we're saying none of the
The
testimony.
lease doesn't say whose obligation it is to fix the fire
Well,
escape, right?
Right. Well, Figler
So there's nothing in the lease that answers this question, correct?
that is correct. But when there's
So
silence in the
Isn't that the heart of ambiguity, that there's nothing clear about it?
Well, there's case law to the effect when the lease is silent as to certain things. There's a case of
And is there any case law saying that a lease that's silent on fire escapes, as a matter of law, means that the landlord is not responsible?
Well, there's a case that Figler v. Supin that says courts will not expand on the landlord's repair obligation beyond those express limitations, and it wasn't expressly, the fire escape was not expressly stated in the lease, and all the parties to the action believed, or at least there's not any testimony to the contrary, but all the testimony that we've taken in this case believed that
But
the
you
fire
say
escape...
all the parties to the contract believed that, but there hasn't been any testimony by the tenant, right?
Well, the tenant wasn't deposed.
I understand, but you said the parties to the lease all agreed on that, but there hasn't been any
Well,
testimony by...
there was...
Excuse me, has there been any testimony by the tenant?
I don't believe so. But there was testimony by...
You can't talk about what all the parties to the lease believe, right?
But we can testify as to what their course of conduct. That's what AHRC, the tenant, did. The tenant, in fact, went immediately, called their repair service to fix it. That speaks to their beliefs under the lease. I would think so. It's not testimony, but it's their actions. And there is considerable testimony, not from AHRC, but from the draft or from the manager of the lease and from the manager of the building. The business manager from the church. That they both believed that the fire escape had nothing to do, was not under their obligations as a.
They testified that it was the tenant's obligation?
Yes, both of them did.
Where do they get that from?
They testified based on their. The manager testified based on his understanding of the lease, which I don't know if he wrote the lease, but he's managed the lease and the lease extensions. And the business manager who is the liaison between the church and the tenant testified explicitly that it was the tenant's obligation.
They get that from the lease that we're all reading, and we don't see the tenant specifically mentioned as the one that's responsible for it, but they somehow read that from that lease. We've established that the lease is silent to that, but there is case law when the lease is silent as to a number of things. It's silent as to doorknobs. It's silent as to a number of the bathrooms. That doesn't necessarily imply that the landlord, the out-of-possession landlord, would be responsible for that. It's just there's certain things that are obvious. And the question is, maybe it's a case of first impression.
Okay, got it. What you hear the first impression? Thank you very much. Karen's versus City of New York. Last but not least, welcome to the new year.
Good afternoon, Your Honors. My name is Steve Sinaiko. I'm with Cohen and Gresser, and I am pleased to be here this afternoon on behalf of the Children's Aid Society. Contrary to the plaintiff's assertion, this case is not one in which Children's Aid is asking Your Honors to apply a heightened pleading standard or a requirement of pleading with particularity. Rather, what we are asking the court to do is to apply settled New York law, including this court's own precedents, relating to the standard that governs motions to dismiss under CPLR 3211A7 in cases where a plaintiff seeks to hold the defendant responsible for tortious conduct by a third person. Settled New York law is that liability depends on the defendant having advanced notice of a propensity on the part of the third person to engage in the conduct that's alleged. And this court and others have held that simply asserting in a complaint the defendant knew or should have known of the propensities of the attacker for this conduct, that's not enough. Court has said it in Nagel, court has said it in Hammond. And other courts have applied that same principle in CVA cases. The rule is that in order to avoid dismissal,
But that's not all that the plaintiff alleged here. The plaintiff alleged here that Children's Aid was told about the abuse and did nothing, and therefore the abuse continued. That is a different circumstance from on information and belief I should have known, right? And on a pre-answer motion to dismiss, we have to assume that that allegation is correct. Maybe it's not correct. Maybe there is no proof of that. But that's what the plaintiff alleges, that Children's Aid was told and still nothing happened.
Your Honor, I think Your Honor may be mistaken about the record. There is no allegation in the complaint that plaintiff or anybody ever reported this abuse to anybody. There is no such allegation. There is an allegation at paragraph 82 of the complaint stating that after actual discovery of the abuse, nothing was done. But in our view,
in order for there to be discovery, they had to have been told about it. That suggests that that is a way of stating that they were informed, because otherwise they wouldn't have discovered it.
respectfully, Your Honor, I disagree. I actually don't think that there's any logical or material difference between saying the defendant knew or should have known of the abuse. That allegation under the law is insufficient without allegations of facts that would support the notion that the defendant somehow was aware of a propensity on the part of the attacker to engage in the behavior. I respectfully...
But it says, even after actual discovery of the abuse, then that means that they had to have discovery of it, that they knew about it. And once doesn't that change things significantly?
Respectfully, Your Honor, I submit that it doesn't. And the reason is that simply saying after actual discovery, any plaintiff can say that any time. It is not materially different from saying the plaintiff knew. Assume for a moment that the allegation...
No, wait, you're saying to us that after discovering that this child was, all allegations, abusing another child, the defendant did not stop the abuse, that's the same as saying on information and belief they had notice?
Your Honor,
Don't forget, we have to construe this complaint the most liberally way possible. It may not be the most artful pleading, but that's what the pleading says, that the Children's Aid was informed or somehow knew or got notice that this child was abusing the plaintiff and did not stop the abuse, which continued. That's, in its whatever inartful way you want to say it, that's the allegation. That's what makes this different, I think.
Your Honor, again, I respectfully disagree.
Okay.
I think our view is that if the plaintiff had alleged the defendant knew without providing any facts, and for example, the defendant could have, the plaintiff could have alleged, I informed the defendants. The plaintiff could have alleged there were witnesses. The plaintiff could have alleged somebody else informed the defendant at a place and time that this was going on. That's not present, and in the absence of those kind of factual allegations, our position respectfully is that simply saying after actual discovery is not materially or logically, yes, Your Honor.
So you're suggesting that there's a required formula for indicating prior notice, and I don't see anything in the case law that says that. It seems to me that their allegation, for example, besides paragraph 82, but also in paragraph 80 where they say, after becoming aware of indicia that the plaintiff and potentially other children were being sexually abused by other children under their supervision, is further evidence, is a further appropriate allegation of notice.
Your Honor, I respectfully disagree with that as well.
Is there can you cite me anything that says it has to be stated in a certain way or it's not good enough?
There is no, I don't think there's a requirement that notice be alleged in any particular formulaic way. There is a requirement that there be facts alleged that in the complaint that, if true, would give rise to a reasonable inference that the defendant, the attacker had a propensity to...
And here the allegation is actual discovery of the abuse of plaintiff.
Right.
Why isn't that a specific fact?
Because in our view, Your Honor, that allegation can be made in any case.
Well, if it turns out that the plaintiff had made baseless allegations, you have your remedies for that down the road, but that doesn't come into play in a 3211 motion.
Well, I mean, again, Your
I mean, if
Honor.
it turns that plaintiff was saying things for which it had no basis at all in law or fact, there are remedies for that in terms of the sanctions and so on. But at this point, we have to assume that what's in the complaint is true.
Understood, but our position is that there is not a material difference between actually discovered and the plaintiff knew, and that really what it depends on is that there be allegations of fact to support either one of those assertions that are absent in this complaint.
Thank you. You have rebuttal time.
Thank you, Your Honors.
Good afternoon, Your Honors. Douglas Herring of Certain Zilberg for the plaintiff respondent. Appellant and I are in complete agreement that this case, this appeal can be decided easily by applying this court's own prior decisions, specifically.
Well, wait a second. I want to ask you, I mean, that's the negligence cause of action, but I want to ask you about the negligent hiring and supervision cause of action.
Certainly.
Are you saying, what fact other than it was they were negligently supervised? And if you're saying the fact of the abuse itself is a fortiori enough?
No, Your Honor. So
tell me what facts in the complaint, because I understand you have a complaint of negligence. You say they got notice, they did nothing about it, that's negligence. But what about the hiring and retention claim?
So with respect to the hiring and retention claim, that differs from the pure negligence claim. The pure negligence claim looks to the society's action.
I just want to know what
respect to the
facts
plaintiff.
you are supporting that claim with.
Right. So with respect to the negligent hiring and retention supervision claim, that deals more with the facts of Good Hugh Centers and Children's Aid Society's behavior with respect to its employees at the Good Hugh Center. And specifically, we allege a pattern and practice of lax supervision and...
Right, but what you can't, again, I do agree that you can't just say it without any factual basis.
So based upon the repeated instances of abuse that occurred, both physical abuse, which was reported to the city, that is not part of this action, as well as the sexual abuse that is part of this action, it is alleged that there was a pattern and practice of a failure to supervise stemming from a failure to train or adequately teach the employees at the Good Hugh Center how to do their jobs, and for continuing to retain them.
I didn't see those allegations in the complaint. That's what I'm trying to say to you. I didn't see those allegations. I did see the allegation that it was negligent once you were put on notice of behavior, not to do anything about it. That's the negligence claim. But I didn't see any facts underlying the claim that the employees were negligently trained or whatever, other than saying it, and the fact of the abuse, which I don't think generally the courts say is enough. So that's why I keep asking you, what else do you got?
Certainly. So paragraphs 64 and 65 of the complaint do allege that the abuse would not have occurred had the duties, the contractually obligated duties to supervise and train their staff had been carried out effectively. I understand Your Honor's point. However, keeping in mind that this is, in fact...
Again, that would essentially mean that any time abuse occurred, that would be a good claim.
Counsel, what about paragraph 78 of the complaint, where you allege that they failed to discipline employees who exhibited extremely poor judgment?
Yes, Your Honor. That is an example of the pattern and practice of behavior that had the duties of the employees been discharged in accordance with the duties, the contractual obligations with the city's statutory duties, the abuse would not have occurred. And yes, failing to discipline employees and continuing to retain them after they had reason to know that they were not adequately detecting, reporting, preventing abuse, supervising the children, et cetera, all the duties we expect. Finally, I just want to briefly turn to Appellant's argument regarding the social services law claim. And as trial courts have held, the specific language of Section 420 of the social services law authorizes private rights of action against any institution with a reporting obligation that fails to do so. So the argument by Appellant that as an institution, Children's Aid Society did not have an obligation to report simply ignores the plain language of the statute. There are no further questions.
Thank you. Thank you.
Thank you.
Just a few words in rebuttal, Your Honors. First of all, with respect to, and maybe there's just a disagreement here, but with respect to the allegation, the complaint that there was actual discovery. I guess our view is that if allegations of that nature, if allegations of the sort that, that in some amorphous way the defendant failed to discipline its employees, but without concrete factual allegations, if that's enough to survive a motion to dismiss, then the meaning of Nagel and Hammond is greatly reduced or eliminated. That's point number one. Point number two, with respect to the social services law, it is correct that Section 420 of the Social Services Law does refer to a willful failure to report by an institution. However, I think the more salient point is that the obligation to report under Section 413(1)A of the Social Services Law applies to a laundry list of individuals, but not institutions. There is a provision, Section 413(1)B of the Social Services Law, that refers to what's supposed to happen at an institution when an individual makes a report. What is supposed to happen is that the individual is supposed to inform the institution, and the institution then has responsibility for administration of the report. Our view is that the reference in the initial clauses of Section 420 to willful failure to report by an institution would have to do with the failure to administer a report after something was brought to the institution's attention by one of its employees who in fact did have an individual reporting obligation, and there is no allegation in the complaint that any of that happened in this case.
Okay, thank you.
Thank you, Your Honors. Thanks for hearing us on the first day of the year.